Supplementary list. Supplementary list for pronouncement of judgment. Item 43.
Judgment.
In view of the above discussion, we don't find any case for interference in this intra-court appeal, hence the appeal is dismissed. The interim order passed by this court in this intra-court appeal is hereby vacated. The respondent number 7 forthwith be appointed as principal, Baleshwar Higher Secondary School, Jabalpur, Kachar. The respondent number 7 is entitled to for all the consequential benefits except the salary of the post of principals for the period he has actually not worked as principal.
From item number 1 to 5. Item number 6 to 40. From item number 50 to 27.
May please, Lord Rosi. My lord, I want to mention item number 16. I have appeared for the petitioners.
Fine.
And the respondent bank, my lord, it relates to OTS, one-time settlement. And the respondent bank has filed affidavit in opposition for the IA case and the WPC case. And I am going to submit, my lord, the affidavit in reply. And it is already under preparation, my lord. The statement of account is not furnished to me. And that's why 2 weeks time may kindly be granted.
Have you informed the other side?
On the other side, I have informed.
Learned concept of the petition.
Huh?
He submitted that.
My lord, an interim order, it may be continued.
I submitted
19,
in response to the county filed on behalf of
1990.
region, counter affidavit is required to be filed. Therefore, some time may be granted. Time paid for is granted. List after 2 weeks, whatever the date may be. List on so and so. Interim order, if any, to continue till next stage.
Well, another point, our name was not shown in WPC because other advocates, they have already withdrawn their Okalatnama. My name is S. Sorman.
Name of Mr. Sohn. In the cause list.
Master list, master.
Lordship's permission at item number 15 and 21.
15 and 21.
My lord, we have filed affidavits in the matter by the respondents, my lord. Could it be called on record? If otherwise.
Call for the affidavits.
Obligation.
May I please, Your Lordship? Lordship, I beg to mention item number 17 for adjournment as my senior Mr. S. Committee is out of station.
The request of the learned concept for the petitioner matter is urgent.
Lordship, kindly matter may be taken up on 28th of February. Deeply obliged.
Yes.
May I please, Lordship? Lordship, with the consent of other side, I beg to mention item number 25 to 27, Lordship.
Fine.
Lordship, it may come after a week, Lordship.
After a week,
Lordship,
you are for the
appealants, Lordship.
appellants. We informed the other side.
Lordship, yeah.
I'm appearing for that. In fact, one of this matter has become infructuous also otherwise.
Why?
Because the work in question has already been executed by the tenderer whom they had initially given. We challenged it. The single judge ruled in our favor, notwithstanding that it has been more than a year, my lord. They are doing nothing, my lord. Now they have come up. There is no stay order also. Now they have come up in appeal. That too after a lapse of so many years, my lord. We have filed appropriate contempt petition that will take care of the contempt petition is there, my lord, before the single judge.
It may be heard, Lordship.
So still the work has not been started or what?
Work is at the verge of completion.
The verge of completion. Then why
Completion.
you have filed by this appellant?
Appellant is the railways, my lord. Appellant has given it to a private party. We have challenged it at the initial stage. There was
The
a
private party has already completed the work.
already completed. I am told that they have already completed. Now, my lord, but the instruction should come from them, my lord. The ones that-
At the request of the concept of the appellant, this matter after a week he got dead.
Past of March.
I'm obliged.
That legal lordship. Lordship, Baker mentioned item number 32, lordship.
Yeah.
That may be taken up after 2 weeks, lordship.
The request of the concept of the appellant, this matter after 2 weeks. Yes.
Okay.
Lordship, with respect to item number 31, here Lordship challenge is made to section 16(4) of GSTA. Other days, Lordship, and the matter is pending before the Honorable Supreme Court, Lordship, in one of the assembly. May appear that may be taken after a month, Lordship.
Yes,
Okay, I'm for a petitioner.
you are for the petitioner. So the thing, the matter is pending before the Supreme Court, that validity part.
Yes,
Similar order
in
being.
Patna High Court, Lordship, validity
ruled
was
in your
upheld.
favor. Learned concept of the respondent has submitted that the matter regarding the validity of rule 16(4) of the section 16(4) of the GST Act is not in consideration before the Honorable Supreme Court, therefore matter may be adjourned. List after list after 8 weeks.
Much of.
Keep looking.
May it please your lordship, I beg to mention item 42 of today's daily list. Lordship, the matter has been wrongly listed along with item 40 and 41.
Item number
42, your lordship.
42.
Yes, your lordship.
Not connected matter.
Lordship, this matter pertains to promotion, your lordship. It's a civil bench 3 matter.
And my lord, it is wrongly listed. So far, my lord, order dated 6/12 to before is concerned. It should be listed on with 5718. But listed with 5781. So it should be dealing and may not direction may be.
The parties have submitted 42. The learning concept of the parties have submitted that this matter has wrongly been carried with the other matters. It is submitted that this writ petition is required to be listed along with WPC number 571/2023.
5718.
5718.
18.
5718. Stop. Taking into consideration the submissions made on behalf of the
After 1 week, my lord. And Lojima code also, there is order that 5718 is connected with writ appeal 3 to 5.
Where is the order? This is not the order. So items 40 and 41 is required to be listed with WPC number 5718 of 2020. But wrongly 5781 of 2023.
Yes, your
No.
lordship.
So then the other matters will also have to be adjourned.
And my lord, item now 42 is to be dealing. And
Yes,
to 40 and 41, my lord, after 1 week, my lord. With 5718.
number 40, 41, or 42 may common order. Stop. Then in concept, the parties have submitted that the WPC number 5781 has wrongly been tagged with the writ with the above with the writ appeals number 325 and 262 public 2023. It is prayed that the WPC number it is prayed that writ petition number 5781 be listed along with 5718.
Writ appeal number 325.
It is prayed that writ appeal number 325 and 262/2023 be listed along with WPC number 5718. WPC number 5718. Public 2023. Ordered accordingly. In view of the above, this writ petition number 57881 oblique 2023 be detached from writ appeal number 325 and writ appeal number 262/2023 and be listed along with WPC number 5718/2023
After 1 year.
after 2 weeks.
I love that.
The writ appeals number 325. Actually, उसी के साथ लगी. After 2 weeks, that's all.
May I please your lordship, with consent from the other side lordship, I beg to mention for item number 39 lordship.
Yeah.
In this case lordship, we need 4 weeks time to file affidavit lordship.
Date may be changed, one day and date may
At
be.
the request of the London Council, the respondent list this matter on so and so. Date लगा दी. After 4 weeks की date.
Diplomat.
May I please, your lordship. Lordship, with the consent of other side, I beg to mention item number 38. I am seeking adjournment on the ground that an additional affidavit was filed by the respondent number 9 yesterday itself. So I need some time to seek instruction on this.
Will adjourn or will pass an order on it. You wait for that.
Daily list for orders items.
May I plead the lordship, my lord, I pray for lifting of a urgent appeal tomorrow, my lord. My lord, in this matter, my lord, the petitioner is the settlement holder of a market, my lord. Without serving a notice of the writ petition on the appeal, my lord, his settlement has been set aside and quashed, my lord. And the writ petitioner, my lord, who has been adjudged as ineligible bidder in the by the tender evaluation committee, the honorable single judge has directed to settle the market with the ineligible bidder, my lord.
You have
And
not
my
been made
settlement
party-
has been
you have not
cancelled.
been made party in the writ petition.
I have been made party, my lord. The honorable court has been pleased to issue notice, my lord. The registered post with AD notice has not been served upon the appellant. And dusty service, my lord, in the dusty service method affidavit, my lord, they have falsely stated that, my lord, the appellant has refused to accept the notice of the writ petition, my lord. Whereas it has not been served on the writ petitioner, my lord.
Tomorrow.
Obliged, my lord.
May I please, your lordship. Actually, I beg to mention for listing of a writ petition lordship pertaining to transfer matter lordship, challenging the order of the honorable cap lordship. So matter may kindly be lordship taken up day after tomorrow lordship. Urgency is there because of transfer matter lordship. Obliged, lord.
May I please your lordship, I beg to mention for listing of a writ appeal. The case was filed on 16/11/2023. The honorable single bench has. Okay.
May I please, Your Lordship? Lordship, I beg for listing a I, Lordship, relating to the condonation of delay, Lordship.
Next week.
No. Obliged.
Daily list for orders, item 1.
My lord, I have filed the dusty affidavit, my lord.
Duly served upon the respondent number 8, 10, 15, and
18, my lord.
18.
Yes, my lord. Office note dated, my lord, 29/11/2023, my lord. My lord, I have filed the affidavit and that has been reflected in the office note.
I am for 1 to 5, Lord, the respond number 1 to 5,
Only 1 to 5.
only 1 to 5.
And what about the other respondents?
Others are served, my lord, only 3, these 4 were, my lord. As per the office note dated,
You have filed the affidavit.
yes, my lord.
When?
My lord, I have filed in 21/11/23, my lord.
23, 1. 23, 1.
21/11/23, probably.
21, 11 to
23, my lord. November 23, my lord.
Okay. An affidavit is filed on behalf of the appellants.
Petitioners.
On behalf of the petitioners. Contending that the notices upon the respondent number 8, 10, 15, and 18 has been duly served. Stop. In view of the above, the service upon the respondent number 8, 10, 15, and 18 is treated as complete. This matter for admission after 2 weeks.
My lord, it is probably admitted, my lord. Thereafter, my lord, notices has been issued, my lord. Again, my lord, 1 second, my lord.
The office to proceed.
Admitted on 15/23.
15/3/23, my lord. Deeply obliged.
Item number 2.
May please your lordship. Yesterday I filed an indictment petition, lordship, so which is not in record. So kindly possible for the
Nikhil, in concept of the submitted that completement application completement application is filed yesterday only. Office to take the same along with the take the same and list this matter after 2 weeks.
Lordship, copy has not been served upon me.
Obliged.
Obliged, Lordship.
Item number 3.
May it please, Your Lordship. This is a review petition referred by the state, my lord. Challenging the order dated 10/8/2018. Passed in the WA number, my lord, 304/2014, my lord. While preparing the review petition, there is delay of 557 days, my lord. So I have explained the delay in the delay condonation petition. Subsequently, this honorable court directed me to file the relevant document, my lord. Accordingly, I have filed an additional affidavit, my lord. It is filed on 22nd of September 2023.
Have you filed the SLP?
No, my lord. We have not filed the SLP, my lord. While preparing the SLP, it came to the notice of the department, my lord, that there are subsequent development which could not be brought on record during the appellate proceeding, my lord. So, my lord, we have
557 days delay.
yes, my lord.
The time of drafting of SLP.
In fact, my lord,
once you have decided to file an SLP,
yes, my lord.
then certainly at the how much time will take to draft the SLP?
My lord, before
My lord, SLP to file, they took the decision on 4/9/2018. And on 10/9/2018, the steps for SLP was taken. 29/2018, the grounds for SLP was drafted. Then they sought to prepare an appeal against the order. From 2018, my lord, 2012, 2018, there is no explanation of the delay till the filing of this review application on 18 to 2020.
Yeah, well, our ground for review is, well, during the proceeding,
Ground of review, we'll consider later. First show us that you explained the delay in filing the review application.
yes, well,
Not exactly day to day, but at least some convincing reasons was there.
yes, well, in my additional affidavit, well, I have annexed all the communications, interdepartmental communications, and
Okay, interdepartmental communication now from December 2018
yes, madam.
till date of filing of this
Review
review application.
on 18
What is
to
the,
20.
what transpired between all the officers or officers or what? What do you mention?
Nothing,
Madam,
madam.
after that, madam, since there was another departmental screening committee was going on, madam, during this process, madam.
Go on with the departmental screening.
And in fact,
No
madam,
problem at all.
subsequently, madam, they have accepted the fresh appointment also, madam.
Which fresh appointment?
We have, I had mentioned in the supplementary additional affidavit, madam. During the year 1991 to between 2001, madam, there was a huge number of illegal appointments in the state of Assam, madam. Then, madam, pursuant to the order of this honorable court, madam, government took a decision to constitute a screening committee to verify that illegal or irregular appointees, madam. Accordingly, madam, the respondents, they have participated in that screening process, and subsequently cabinet took a decision to accommodate those illegal appointees, my lord, with a fresh appointment. Accordingly, the respondents, they have accepted that appointment, my lord, and now they are performing their duties, my lord. At paragraph 14 of the additional affidavit, I have mentioned that, my lord.
My lord, with your lordship permission, my lord. My lord, what has happened after the direction of the honorable court was to take us back as assistant teachers. We are beggars, my lord, we can't be choosers, my lord. What they did after the judgment of this honorable court, they asked us to appear before the screening committee. They did not give us the post of assistant teacher. That's why we filed a contempt petition. Then, my lord, they gave us the post of tutors, my lord. And that contempt petition is also taken. And they kept us
That
waiting.
contempt petition is still pending.
Yes, yes, madam. This contempt. Item 4 is the contempt petition.
But you should, they are seeking review of the DB order. Division bench. They are seeking review of the division bench order.
Yes, my lord.
Which has affirmed the order of the learned single judge.
No, my lord. Learned singles dismiss the repetition, my lord. Upholding the termination of the respondents, my lord.
Supply the copy of the division bench order.
My lord, your lordship will find that operative portion at page 232, paragraph number 17 of the review petition.
Review petition.
Paragraph number 17. They wanted to delay the process and do not want to comply with this. Paragraph number 17, my lord, it speaks of their actions, my lord. At page 232. If my page number tallies with my lord. We filed a writ petition, your lordship will find in 2010. Yes, ma'am. Yes, ma'am.
বহুত মানুহ আছে বহুতে নিশ্চয় মানুহ
My lord, what seems the worry of the government is that this judgment of the division bench should not be act as a precedent. I have no objection if your lordships observe in the review that this judgment of the honorable division bench is only.
As a precedent, can't be treated as a precedent. In fact, it is, the judgment was passed in the facts and circumstances of that case.
Yes, my lord. Yes. Only I think
Treated as.
the anxiety expressed by them in the review is that this should act as a precedent. That your lordship can always clarify. It is in the facts and circumstances of that particular case.
Fine, there is no question of any clarification on that aspect.
Yes, ma'am. But since my learned friend has come, my lord, that's why. But they have not yet complied with the orders of the honorable division bench, and that condemned petition is listed today as item number 4.
This review petition was preferred on
It was filed on 18 to 2020.
18 to
20. 20. 18 to 20. And your lordship will find the last communication is at page 52 of the review petition. Here, as your lordship has rightly said, it is of 20th December 2018.
page 52.
52 of the additional affidavit in IA number 819 of 2020.
Is the communication 20th with reference to the above elementary education cited, I am directed to request you to furnish a copy of the appeal petition number so and so to the government immediately onward. Submission to the advocate on record, standing counsel for the state of Assam, Supreme Court of India. That is only in relation to that.
Yes, madam.
Thereafter, when you took this decision to file a review petition, where is that? And which authority has taken this?
Yes, madam.
Mainly we want to.
Malad, in the delay condonation application, Malad, paragraph 4, Malad. Though Malad, date of decision has not been mentioned in the paragraph, Malad. But while we have.
Decision was taken immediately in the year 2018 itself. What is the ground for you to, after more than a year, prefer this?
Because Malad, while we're preparing the SLP, Malad, then it has come to our notice. Thereafter, we have. But Malad, subsequently, Malad, they have accepted our fresh appointment with the condition that they will forego their past claim, Malad.
What is the option with them? What is the option with them? Past claims, what past claims?
Any past claim, Malad.
Any past claim, what do you mean by regularization of service? The court has given a direction to regularize their services with all consequential, except the back wages.
Malad, in the fresh appointment order, it has been mentioned that the accommodated teacher will get the prospective effect with effect from 1/11/2020 only, and he
So
cannot
they have
claim.
accepted it.
Yes,
They
ma'am, they have accepted.
Then what remains in this review petition even? You have offered them appointment on
Yes, ma'am, they
different posts, they have accepted it. You place this facts before the contempt court, that's all.
They have
Why
accepted.
why this review petition now? Why you are seeking review?
My lord, we have filed a review in the year February 2020, and the appointment was given in the month of November 2020, my lord.
What remains
Subsequently,
now
my lord.
in this review petition? What remains?
My lord may observe that, and my lord may close it, my lord.
There is no question of observing. Why should we give observe? It's between the adjustment between you and the persons agree.
Well, what has happened? Because this contempt petition was filed on
Whatever
29.
it may be, sir.
Yes.
If they are happy that you have
They have
accepted some other appointment or whatever it may be, we are not concerned with that. You
No, madam.
accepted it or not accepted it, it is for the contempt court to decide.
Yes.
How we are concerned. We are about this review petition only and this is hopelessly time barred.
Close to it. Will not accept it. Close to it.
In that case, my lord, may pay matter may be taken up day after tomorrow so that I can obtain.
What instructions now you would need?
My lord, may take it up tomorrow also, my lord.
But tomorrow, morning.
Sorry.
Tomorrow at two,
At 2, my lord, at 2.
at two,
At-
no, today at two,
Yes, my lord, at 2 today.
today at two.
Item number 5,
Deeply obliged.
No such steps for respondent number 4 and 8. You are appearing.
My lord, in this case, my lord, senior counsel J. Roy appears, my lord, perhaps lordship may not like to take up.
So before the another bench, one of which that can up. Not a member.
Deeply.
item 6,
No steps. Steps for service of notice not received. Yes, Mr. You are appearing for the respondents.
And for the respondent also.
All the respondents.
No, no, no. I am for the respondent number 10.
Only respondent number 10. The private person.
Seven, eight, nine, sorry, standing council.
As per the office report. Steps for service of notice upon respondent number 7, 8 and 9. Has not been taken. It would stop. 2 weeks time is granted to do the needful. None present for the. 2 weeks time is granted to do the needful.
Obliged.
item 7,
May it please the lordship. My lord, in order to comply with the direction of this honorable court, the director has submitted a report before the government, and we are awaiting instruction and approval from the government, my lord. I don't know, give us 3 weeks time, my lord. In the meantime,
You comply with the order.
to comply with the order. We have already submitted a report before the government because the period when they were terminated, in respect of some similarly situated candidates, the government has regularized that period. And for that, my lord, we have already sought an instruction from the government. Here, the contender is only the director, my lord. Government is not a party.
In the concept of the respondent has submitted that principally the government has decided to comply with the order passed by
My lord, the director has sent the approval.
submitted that the director has already sent the recommendation for complying the direction. It is submitted by the concept of the petitioner that the director, secondary education, Assam, has already recommended the matter for compliance of the order passed by this court. It takes some time to this court, and therefore some time may be granted. List up to 3 weeks.
Item 8.
May please your lordship. Lord, I'm for the petitioner here.
Yes. Who is for the respondent number 2?
I'm for the respondent number 2. My respondent number 2.
And
my
who is the
instruction is-
respondent number 1?
Worker number 1 is the deputy commissioner of the metro, my lord. He is Mr. Sumit Satwan.
This is not complete on the respondent number 1.
That is have I complete the respondent number?
I haven't checked, Lordship, let me, because I have taken steps, Lordship, immediately after Lordship had issued notices.
As per the office report, service of notice upon the respondent number 1 is not complete. Let fresh notice be issued to the respondent number 1. Through registered AD, returnable on so and so.
Okay. Okay.
Item 9.
May it please the lordship. This delay continuation application is preferred. Praying for continuing delay of 44 days, my lord. Notice on respondent number 8 has not yet been served, my lord.
Who is respondent number 8?
Mriganko Kotoki, my lord. Last, I have taken steps on 23rd of January, my lord, in the correct address of the respondent number 8.
There is an office note of 23rd of January, and so we have to await.
Await service report on the respondent number 8 for 3 more weeks.
Obliged.
I'm appealing for respondent number 6 and 7.
Saga, then आपकी presence may be marked.
Item 10.
Captain India. 108 days written.
Steps में
शायद बाहर का मैटर है, मणिपुर का मैटर है। अब इस समय में वही जाते हो गया, लेकिन मेरे को सुप्रीम कोर्ट का ऑर्डर है बहुत भी लगा होगा आए भी
Pursuant to the direction given by this court on 8/11/2023, no steps were taken for service of notice upon the respondent. Stop. 3 weeks time is granted to do the needful.
None appears to apply.
None appears for the
Item 11.
This side is always tougher. Well, at 153 days delay.
Let us see.
Well, 153 days delay. They are on the earlier date, well, they short time to file an objection, but the objection has not come on record. They have not yet to file or they are not willing
No,
to
we are
file.
not filing it, but this delay has to be explained.
কোনটাকে ফল বলে এপিলটা কোন একটা বলছো না
Main matters. Employees.
রিলেটিভ অবজেকশন দিয়ে মানে আমি ইন্টারমিডিয়েট হ্যাঁ হ্যাঁ ও,
They are already in dispute. Yes. What do you want to say about this?
Lordship, as far as the delay part is concerned, this is 153 days delay. And they are all local people, Lordship, and they have an association. And like the delay,
That association is almost defunct and they are dispersed here and there and then. It's, after all, these people are already in distress. But we'll hear it on merit.
Lordship. Otherwise also, I don't think he has as much merit in the matter. Anyways, Lordship.
The matter of the consultation of the IA number 3668 of 2023 in writ appeal number IA number with a prayer to condone the delay of 153 days in filing the connected appeal. No counter to the IA is filed on behalf of the respondents. We have heard the learned concept of the applicant. Then the learned concept of the applicant has submitted that the delay in filing the present, the delay in filing the writ appeal, connected writ appeal is bona fide, and there was no intention on the part of the appellant to file the connected appeal with a delay. Full stop. Learned counsel of the respondent has opposed the application, having heard the learned counsel for the parties, and after going through the contents of the application, we deem it appropriate to condone the delay of 153 days in filing the connected appeal. Hence, the application under section 5 of the application act is allowed. Delay of 153 days in filing the connected appeal is condoned. Office is directed to register the appeal and thereafter list the same before this court. And after 2 weeks.
We are obliged.
Copies of the memo of application.
Yes, we'll serve it during the course of the day.
We have to mention it or
No, it's not required, madam. We'll not.
we are not in talking terms.
Then we'll mail it.
Item 12.
Okay, matter relates to family pension, Lordship. Rule has been issued in this matter, Lordship. Yes, they have appeared. Counsel for respondent number 5 has already appeared, Lordship. Private respondent number 5.
And Sharma learned appearance. Yes.
My lord, I am for respondent number 1 to 4, my lord.
Have you filed your response?
No, my lord, 2 weeks time may be given to file the response, my lord.
Okay, as per the office report, notice, the service of notice upon all the respondents is complete. None is appearing on behalf of the respondent number 5. However, the counsel appearing for the respondent number 1 to 4 prays for and granted time to file counter to the writ petition. List after
Please come here, my lord. In a March, my lord, 3rd week or 2nd week of March.
whatever the date.
Yes, my lord. 15 March.
Obliged. Item 13.
May I please, Lord, although Lordship, case has been listed for admission, but I pick up the office note. It said that neither the ID card nor the unanswered notice has been returned.
Neither notice upon the respondent is not served.
I'll take fresh steps, Lordship.
Though the matter is listed in admission, but it appears that the notice upon the respondent is not served till date. Stop. Then a concept of the appellant is granted time to take necessary steps for service upon the respondent number.
All respondent.
Service of notice upon the respondent. On on taking those steps, let notice be issued to the respondent. Conference or so and so.
Okay.
Did 4 weeks के बाद.
Item 14.
नाम तो लिखते भी पड़े मैं यहाँ पे तीन जाने का भी बाकी ये सब तो कितना अपने देते हैं ये लेटर ऑफ डिमांड नाम तो लिखा ही नहीं का डिसीजन डिसीजन लिखा नहीं mana last order to mate
So the date of death of the deceased is
2015, my lord.
2015 and
2015.
moved an application.
On 9/6/2015, my lord.
It was rejected on.
On 31/12/2018, my lord.
You approached the court when?
On in 2023, my lord.
Oh,
But the delays I have explained in the writ petitions, my lord. It is the operator who should submit, furnish a copy of the rejection order as per the order passed by this honorable court, my
rejection
lord.
order.
Rejection order, if my case is rejected, that is required to be furnished to me immediately, my lord. That was not done. And when I have approached before the authority, they said my case is in line. In 2023, that order was,
So you, for the first time, you approached in the year 2023 only.
my
Not
lord.
Before that.
Because thereafter, my case was in, recommended by the district level committee, my lord.
So it was rejected in the year 2018.
18,
Then
my
what you were doing till 2023?
My lord, I am approaching the authority, then they said that my case is in line, my lord.
Where is that proof?
My lord, I have stated in my writ petition, my lord, in this, and it is the position of law that, my lord, they should furnish the copy immediately, but that did not do that. And that apart, there are another aspect, my lord.
Where is the rejection order?
Rejection order is at page number, my lord. 109,
Read in, hi.
my lord. Serial number 70, my lord. And was rejected on the ground of underqualified, my lord.
So how you are going?
Eight parts. There are circular in digital, but it cannot be accommodated if the post is applied. Even in a lower floor or in another department. They are permitted by the- But yes, is a technical difference. Was में अभी भी lead कर रहे हैं। cases will delay, but I don't think that the case is okay. It was nice.
What do you want to say?
Well, the honorable court has in paragraph 6 has noticed that for last 5 years, more than 5 years, he did not approach the honorable court. And the need for the compulsion appointment is the immediate the help of the family. That purpose is already kindly come to para 6, page 119. The
We have seen.
honorable court has considered, my lord, that the sole object of the scheme for compassionate appointment being to give immediate succor to the bereaved family, which has lost its sole breadwinner, winner, without would not be applicable in the instant case where the date was in March
So you have
2015.
demonstrated before the learned single judge that during that time he is gainfully employed or he is doing something else. So
No, it was not there. But the thing is that my lord, the conduct on the part of the petitioner is that when the father died in March 2015, ultimately, my lord, although it was rejected in 2018, he waited till 2023. My lord, by this time, 8 years have gone by. And my lord, the law laid down by this honorable court, my lord, in Achyut Ranjan Das's case, it says that the application has to be considered within 2 years. And after, if it cannot be considered for 2 years, but ultimately no further consideration is required. And kindly see, my lord, in fact, but at this point of time, Lord, with effect from April 2017, there is no scheme for compassionate appointment scheme for appointment on compassionate ground in Assam.
2017.
Since April 2017, there is no scheme for appointment on the compassionate scheme. Now, in place of appointment on the compassionate ground, the government has another office memorandum has brought, and that provides the compassionate family pension. But that scheme provides that the person, the deemed date of superannuation is considered by the government, and the family is paid full salary up to the deemed date of superannuation of that deceased employee. So now the appointment at this stage, otherwise also
You are paying them the full salary.
Full salary, the whoever has died after 1/4/2017, the new scheme is applicable to them. Well, at this stage in 2024, my lord, appointment under compassionate appointment scheme is also not, it is not there at this stage.
Yeah, sure. They don't get under the compulsion that come. They'll not come under the time. I'm saying
He sought appointment on which post?
He sought appointment for the post of section assistant.
On post of
Section assistant.
section assistant, and for that he is not having the requisite qualification.
The DLC, as per the DLC recommendation, DLC has recommended for that post. SLC found that he is not qualified for that post.
Fine. If he is not qualified for that grade 3 post, that is section officer is grade 3 post.
Section assistant.
section assistant is grade 3 post.
Grade 3 post.
Then as per the circulars issued by the government from time to time, is not having that requisite qualification, offer him appointment on a lower post.
But at this belated stage, that is my humble submission at this stage, Malad, that after 8 years or 9 years by this time, whether the person, Malad, kindly
You
kindly see,
also took 3 years in taking decision on his application.
Malad, DLC
Now you are blaming him. He moved an application in 2015. You decided it in 2018.
Well, kindly see, Malad, kindly consider, Malad, that the person has no subsisting right for appointment on the compassionate ground.
But at
Malad,
least
it
he
is,
has a right for consideration.
Malad,
Right for consideration is there.
after 9 years, Malad.
After 9 years, we are going by 2018 date.
But 2018, even Malad, after
He was not
2018,
eligible for a particular post. As per your policy in vogue at that time, you were required to offer him appointment on a lower post.
but in 2018, when his case was rejected, that is what the delay is, Malad. In 2023, he has raised the grievance. But by that time, the sole object is not there. Kindly see, Malad, that for object for the purpose
Was
for
very
which.
much there.
Well,
As far as regarding delay is concerned, what is your explanation about the delay you took in taking the decision?
Malad,
In
delay,
2015, he moved an application, you rejected his application in 2018.
Malad,
Almost
2015,
3 years, after 3 years.
Malad, all the
Now
kind
you are saying he approached this court with a delay.
but,
What about your delay?
Malad, page 105, the minute of the SLC,
We moved application in June 2015. And you decided on 31st of December 2018, more than 3 years, so the 3.5 years.
the
And if he has approached the court after 3.5 years or 4 years, what remains? What's the problem?
But the SLC considered hundreds of persons, Malad. Kindly see the minutes of the SLC at page 105.
That is your headache, hundreds or thousands. That is your headache. At least decide those applications within time. You were supposed to decide.
But it was decided in 18, Malad.
Only 2015 application. You decided in 2018. You took more than 3.5 years. And after after rejection of 2019 18 application, he preferred this writ petition in 2023 or 2022.
2023, Malad.
2023, 5 years.
After 5 years.
Not after 5 years.
5 years.
Within 5 years.
Within 5 years.
December 31st of December.
Got it.
19, 20,
In-
21, 22, and 23. That's all.
Got it.
There's not much difference between the time which you took in deciding the application and he took time in approaching this court. But,
But by this time, Malad, the situation has changed to a great extent, Malad. By this time, Malad, in 2024, the scheme for appointment on the compassionate ground is no longer there.
That's right.
And Malad, the
But
vacancy,
at that time when he moved an application, that wasn't in vogue.
it was there. It was there at that
Was
time.
there.
And Malad, the vacancy for who, the vacancy against which Malad, the petitioner is required to be considered, we have to go to that year's vacancy, whether it is available or not. Ultimately,
See, maybe you are right that he was not having that much of the requisite qualification for appointment on the post of section assistant. But ultimately you have to offer the appointment on a lower post as per the policy existing at that time.
but if we need to consider him at this stage, we have to examine the availability of vacancy at that point of time.
Why not?
Whether vacancy is available or not, ultimately
Provided vacancy on that year, there is no necessity of vacancy of this year will also do.
But for compassionate appointment, one of the vacancy for that year we have to consider.
Only 5%.
5% of that vacancy that we have to see. Malad.
5%. Not leading to by efficient material is one thing that one material post study discussion.
Your client had applied for which post?
He applied for section assistant. For actually what happened, my lord, he is a higher secondary pass, but what happened is all the testimonial of higher secondary has been stolen, my lord. And for that, he have to submit the SSLC examination testimonials, your lordship. And as far as Sutrandan Das case, my lord,
What you were saying, DP?
my lord.
What was stolen? क्या हो गया?
My lord. In train journey, my lord. In a journey
What do you
from
mean
train, my
by
lord.
certificate was stolen? You should have obtained a duplicate certificate.
At that time, he don't, but he applied with the SSLC testimonials, my lord.
Ask me a question.
And after
Then
that
there
case,
is
my lord, as per
something-
qualification
something there is
can be
nothing.
considered, my lord. And
You
there is
applied-
order passed by this honorable court also on this aspect, my lord.
What you are contending that the qualification was there, but that
that is
qualification,
I'm
the
submitting,
certificates
madam.
of that qualification
No, no, I'm
were
submitting
stolen
that.
and therefore you were not able to furnish those documents.
No,
That is
I'm not
bizarre.
submitting that. I have submitted the SSLC testimonials, my lord. First, I'm submitting that we have the qualification, but it does not have the testimonial because it was stolen in a train journey, my lord.
You could have optioned a duplicate
My lord, yes,
certificate.
he can apply for the copies, my lord. But my lord, as a Sutandan case, my lord, as per qualification, that may be considered because it is in a Sutandan case, my lord.
I think
So and there is a judgment also passed by this honorable court in various situations. I have annexed
not
also,
for,
my lord.
not for such a person.
My lord.
You have not been able to secure your qualification certificates and even
No, even then, my lord,
and even not applied for even if those documents were not there or stolen, not applied for this duplicate. There is nothing.
my lord, as per Sutandan case, my lord, as per qualification, that may be considered even if he claim for any other post, my lord. This is the settled position of law, my lord. So at this,
Did not have this. That is not the फायदा उठाते हैं. तो इतना तो make sense है. Without having it.
Close for orders.
my lord.
Item 15.
In this case, my lord, today I have received the affidavit filed by them, so I need some time, my lord, to respond to the affidavit, my lord. 2 weeks time may be granted, my lord.
They have already, the committee has already submitted its report that your qualification.
My
is
lord,
not valid.
the committee what they have constituted, my lord, that I need to, committee, my lord, what the, this subject of microbiology. There is no representation from the microbiology department, my lord. Only the zoology, 2 persons, they are the teachers in the college. Ought to have been in the level of university who are for framing the syllabus of the microbiology. There is no representation, nothing, and they are not the syllabus formulator, my lord, in respect of the microbiology department
They are
also.
the experts.
They are not the, my lord, expert in that level of the earlier, my lord, you also will find they have recommended for the biotechnology, my lord. And those in that recommendation, they have incorporated the professors of the university level of that too from the Department of Biotechnology was there. This time they have made the committee, my lord, just taking 2 zoology professor of the college. That is, I need to challenge, my lord. And I will respond to this, my lord. absolutely mechanical, my lord, consideration. That is not from the no discussion with regard to the subject of the microbiology and that to zoology. What are the syllabus of an earlier while they have recommended for the biotechnology, my lord. They have made elaborate discussions on the every aspects, my lord. And thereafter, the experts from the university level.
We can't sit as appellate authority over the opinion of the expert committee.
Yes, lordship, but there are some exceptions also.
If yes, then
I will-
what remains to argue?
No, the exceptions are there, my lord. Your lordship can interfere into the opinion of the experts if prima facie it is found that, my lord, it is not properly considered by the experts, my lord. Your lordship, give me some time I will respond to them. I will file the affidavit, and if required, I will challenge the opinion of the expert.
Petition. The petitioner is seeking essentially a relief. Issue a direction to the respondents to treat the degree of MSc microbiology equivalent to the degree of MSc in geology. Stop. And a concept of the respondent has submitted that expert committee has considered the matter regarding equivalence of the degree possessed by the petitioner to the degree of MSc in geology and found that the degree of MSc in microbiology is not equivalent to the degree of MSc in geology. Stop. Para. Learned concept of the petitioner raise some time to address the court on this issue. When
After 3 weeks, my lord, because my petitioner is
3 weeks as brief. I don't think so there is hardly any matter.
Right, my lord, I had a discussion with the counsel for the Assam University in another court. He told me already a decision has been conveyed in a particular writ petition, and the writ petition was closed. This decision was conveyed by the Assam University also. They are not equivalent. And
What
that
is
is that they will become.
3 weeks, we have already granted 3 weeks.
Ablash.
Item 18.
May please your lordship. But in this case, the respondent was removed from service on the ground of charges. Number one charge was unauthorized absence. Number two was starting a business of his own. And number three was
He was not observed that they were shopping with this property. That the civilians cannot have it in appeal of the principles. Clearly become completely disrupted. When had a vegetable when you look out.
Yeah, having heard the learned concept of the plan. We are of the view that matter requires consideration, hence admit issue notice to the respondent. Returnable. There's only one respondent.
one respondent.
Respondent returnable after 6 weeks. In the meantime, effect and operation of the included order passed by the learned single that shall remain stage.
Item 19.
May I please your lordship.
This writ petition is due to violation of scheme lordship framed by the respondent number 1. That is the scheme, namely lordship CGTMEC, Credit Guarantee Trust Fund for Micro and Small Enterprises lordship. Now, in my case is that, your lordship, that one credit facility has been extended, your lordship, in my favor, lordship, by respondent number 7, lordship. Now, the seed credit facilities is covered by the seed scheme lordship, that is CGTMEC lordship. And the main objective of the CGTMEC, your lordship, to extend credit facilities, lordship, without taking any collateral, your lordship. But in my case, contrary to that scheme, your lordship, the respondent number 7, that is the bank authority, your lordship, have extended the credit facility after obtaining collaterals, your lordship. The sanction data is at page number, your lordship, 62, your lordship. That is my initial credit facilities. That is open cash credit and term loan, your lordship. That is 43,50,000, your lordship. And at 63, your lordship.
Yes.
At page number 63 at the lower portion, your lordship, that credit facility to be covered under CGTMEC as per scheme guidelines has been recorded in the sanction letter itself, your lordship. Now, in this scheme, your lordship, instead of lordship taking collaterals, your lordship, the guarantee has been taken by the seed trust fund, your lordship. And for that reason, your lordship, one annual guarantee fees has to be deducted from the account of the borrower, your lordship. And the statement, lordship, of that open cash credit and, your lordship, that is term loan use, lordship, at page number, your lordship, start from 101, your lordship.
Yes.
Lordship. Lordship, at 11/8/2014, your lordship, the annual guarantee fees of rupees 27,219, your lordship, has been deducted, your lordship, from my open cash credit, your lordship. And in this way, lordship, for that guarantee, your lordship, at page number 102, your lordship, that is first row at, your lordship, 12/5/2015, your lordship. Again, the renewal fees of 16,182 has been deducted. In this way, your lordship, again, your lordship, at page number 104, your lordship, 10/5/2017, your lordship, renewal fees, lordship, for that annual guarantee has been deducted from my account, your lordship. Again, your lordship, 105, your lordship, that is 29 March 2018, your lordship. The annual guarantee fees has been deducted from my account, from both of the account, your lordship. It is open cash credit and term loan, your lordship. But instead of that, your lordship, some collateral has been obtained illegally, your lordship, contrary to the scheme, your lordship. And surprisingly, your lordship, that at page number, your lordship, 173, your lordship,
Yes.
there is notice for eviction, your lordship. In spite of that property, your lordship, that is obtained at a time of initial credit facilities extended in my favor, your lordship, one more property has been recorded in that eviction notice, your lordship. That means in connection with that property also, the recovery proceeding has been initiated, your lordship. Now, my humble prayer, your lordship, my limited prayer, your lordship, to release my that property which has been taken as collateral, your lordship. Because in CGTMEC, your lordship, the primary assets can obtain, your lordship. To my limited knowledge, your lordship. But the collateral property they cannot obtain. They go beyond the country to the scheme, your lordship. And my limited prayer to release my that collateral, your lordship, property. And your lordship, in the meantime, your lordship, the stay the further proceeding, your lordship. My humble prayer, your lordship.
Take down. This Writ petition is filed by the petitioner, essentially challenging the validity of the notice issued by the respondent financial institution under section 13(4) of the securitization and reconstruction of final assets and enforcement of security interest 2000 and hereinafter to refer the SFSC Act. The petitioner has also challenged the validity of the e-auction sale notice dated 16/2/2021. Stop. It is noticed that against the proceedings under section 13(4) of the Securitization Act initiated at the instance of the respondent financial institution, as well as the sale notice, e-auction sale notice dated 16/2/2021. The petitioner has already approached the Debt Recovery Tribunal, Guwahati, by filing essay number 10/2021, and the Debt Recovery Tribunal, Guwahati, filed order dated 17/10/2023, Annexure 20 has already dismissed the said OA. Full stop. We are of the firm opinion that against the order passed by the Debt Recovery Tribunal dated 17/10/2021, the petitioner has an efficacious remedy to prefer an appeal before the tribunal under section 18 of the securitization of the SFSC Act. In such circumstances, we are not inclined to interfere in this petition. The same is therefore dismissed. Will be at liberty to the appellant to avail remedy of appeal before the appellate tribunal under section 18 of the SFSC Act, with liberty to the petitioner.
Item 20.
Here, your lordship, government was supposed to file an affidavit, your lordship.
May I please, lordship? Lordship, we have filed one
Is also supposed to grant you the
Lordship.
relief also.
Lordship, in fact, your lordship, in this case, your lordship, what has happened, your lordship, that the prayer we have made, your lordship,
50%. Who are you, Mr. Petitioner?
petitioner is your lordship, your lordship. Para 1 and 2, your lordship, we have mentioned about his credentials, your lordship. Para 1 and 2, your lordship. He has earlier also filed PILs before this honorable court, praying for better infrastructure and facilities for physically challenged people, your lordship.
Yes.
My lord, my instruction, my lord, I have already filed one affidavit. So many clauses has already been implemented. So for reservation of post in the, my lord, government, private and public sector undertaking, that issue is, my lord, under discussion. My lord, a subcommittee has been constituted, headed by the Minister of Assam Accord Department, my lord. And meeting was going on. Now, my lord, since my lord, budget session of the assembly is undergone, my lord, they requested me to take some time to, my lord, place such instructions, my lord, regarding reservation of post. Lord, so far other, my lord, clauses are concerned.
Enforcement 60.
Mr. Bothagur, does it not occur to you that the relief we are praying for
Lordship.
may or may not be, it may be a good idea,
Lords,
but do you think this?
this honorable court probably may not direct for legislation, your lordship, if this necessary, your lordship. It is in the policy domain of the government. I understand, your lordship.
Frame a legislation.
Lordship, no, cannot, your lordship. But your lordship, the context in which your lordship we have come, your lordship, there is a, your lordship, memorandum of settlement. In terms of that settlement, your lordship, Home Ministry, your lordship, issued a notification constituting a committee for implementation of that clause. And in the terms of reference of the case of that constitution of the committee, your lordship, this was one of the subject, your lordship, reservation of the post, your lordship. In terms of that, the constitutive committee submitted its report, your lordship. And in that context, your lordship, we are before this honorable court, your lordship. Otherwise, your lordship, if it is a plain and simple case of seeking a direction for legislation, that would not have been, your lordship.
High Court may be. Finally, can the High Court issue a direction?
Also reference to
And they are considering this.
also reference to the committee.
Lordship may kindly peruse the clause 6 for a moment, page 29 of the Assam Accord, page 29 of this application.
Okay.
This is clause 6 of the Assam Accord.
Yes.
There is no specific, my lord, provision for reservation of post in this clause, my lord.
Municipally, they agreed that there may be, that they will have some provision to give benefit to the Assamese people.
Yes.
There.
What is it? There.
In spite of that, my lord, we are trying to do something, my lord. To safeguard the-
The question is, whatever benefit, obviously it is for the government and the department. But can the read code issue a mandamus? That's the only question here.
Your lordship to legislate, probably your lordship cannot, your lordship, but your lordship will kindly come to page 38, your lordship, for a moment, your lordship. The terms and reference of the committee constituted, your lordship. There is a specific reference. The committee will recommend the appropriate level of reservations in employment under the government of Assam for the Assamese people. It is in the context of your lordship to safeguard the, your lordship, economic security of this.
What they are saying,
They are doing, let them, your lordship, bring up-to-date instruction. Till then, your lordship, this matter.
Then we'll dispose it of that the government has given an undertaking that they are considered
Lords,
suspect.
Lords.
Therefore.
Otherwise, I know where I stand, your lordship. But in this particular context, we have come, your lordship. That's.
Yeah.
And in fact, your lordship, recommendation was made, your lordship, for 80% reservation, your lordship.
That's very well. Let the government do it.
Lordship.
But the read code cannot do it.
Lords.
Will be in the teeth of Article 14.
Lords, I
and 16.
This writ petition is filed by the petitioner in the design of public interest. Essentially, with the the evidence that despite a memorandum of settlement executed between the stakeholder and the then Honorable the Prime Minister of India on 15th of August 1995, certain promises made in those in that memorandum of settlement has not been complied with till date. Stop. The petitioner has prayed that the respondents state be directed to make provision for reservation of 80% of the vacancies under the government of Assam, state government undertakings for SMEs people is also prayed that 70% suitable provision be made for reserving 70% of the vacancies arising in the private sector, including establishment under the PPP mode for SMEs people. It is further prayed that the introduction of reservation laws on the line of Andhra Pradesh employment of local candidates in the industries / factories Act 2019 and the Haryana State Employment of Local Candidates Act 2020. Stop. Response to the petition is filed on behalf of the state, wherein it is mentioned that the matter regarding the safeguard and economic development of the Assamese people is under consideration with the government, which includes for making suitable provision for reserving vacancies in the government's job of government of Assam, state government undertakings for SMEs people, as well as in the private sector also. Full stop. Para. It is submitted by the learned counsel for the respondent states that a committee headed by a cabinet minister is already constituted and is examining the examining for implementation of the clauses of the implementation of the clauses of the memorandum of settlement.
Bracket में Assam Accord.
Assam Accord, and is also considering the various reports submitted by the committees for the implementation of the Assam Accord. Full stop. It is submitted by the learned counsel for the state that the state government is seriously considering the issues raised by the petitioner in this petition, and it is expected that it is expected that necessary appropriate decision in this regard would be taken in a short time. But having considered the submissions made on behalf of the respondent state and also the respondent state, and taking into consideration the fact that the issues raised by the petitioner in this petition are under serious consideration in the state of government, we are of the opinion that in such circumstances, no further order is required to be passed in this PIL petition. However, it is expected that the state of Assam will address the concerns raised by the petitioner in this writ petition expeditiously by making suitable provisions. No further order is required to be passed in this petition. Petition is disposed of.
Obliged, Your Lordship.
Item 21.
I had mentioned this matter in the morning, calling for the affidavit in opposition, my lord. There seems to be some trouble in the e-filing part of it, my lord. The affidavit has not come on record. Otherwise, the affidavit is filed, my lord, then we can.
At the request of the learned counsel for the respondent, is this matter after 2 weeks?
Item 22.
My lord. In the Pradhan Mantri Kishi Samshoy Yojana, PMKSY, per drop more crops in Assam, most of the money that is sanctioned for the poor farmers are not benefited. And most of this money actually is misused, mismanaged, and the benefits of this PMKSY, PADMC schemes are not reaching the people, the poor farmers. Corruption and mismanagement in the agriculture department.
Yes.
Yeah. A writer reply has revealed all these things. My lord, in page number 75, page number
Yes.
page number 83, my lord, 80, sorry. My page number one letter is there from
83.
83.
Yes. Yes.
A letter is there from the DO of the Morrigaon district.
Yes.
Here it is asked in the number 3, whether the beneficiaries paid beneficiary share to the companies in what form, that is cash, online, checks, draft like this. But the DO, the ADOs of the circles has in the page number 86, page number 86.
Yes.
They have avoided all they have replied 1 to 6 several answers, but they have avoided these questions because most of these 15% beneficiary contributions have not paid by this one, by the farmers and fake beneficiaries.
Where that money has gone?
No, only they are concerned about 85% government subsidies for the farmers. They have embezzled these 85% subsidies.
Who has embezzled?
These some corrupt officers from the agriculture department, along with the micro irrigation companies and the vendors.
File a complaint
Complaint was filed
with
with
the police.
police, yes.
Where is
They have
that?
not registered the case.
Then file a complaint in the court.
No, I have already filed a case, FIR in the CM Vigilance Police Station. And
what
they have
happened
not
to
taken any action, not
What
registered the
happened-
case.
What happened to that FIR?
FIR was not registered. They have already forwarded the register for departmental inquiry.
File a complaint before the court concerned.
I have come to this honorable call for
We can't, in this manner, sir, you have leveled allegation that those persons, these officials have embezzled the money.
Yeah.
Then the proper, that is, mechanism is there. If you are complaining about any, commission of a cognizable offense, approach the court.
No,
There is a mechanism in the CRPC itself. Approach the court.
I approached this honorable court for.
This court is not for that purpose, sir.
Yeah.
For registering a criminal case, you have to take records of the provisions of the CRPC. For that, you can very well file a complaint for complaining about a commission of a cognizable offense. The court will consider it. And thereafter, whatever the order, section 156, this CRPC is very clear.
My prayer is that notices may be issued to this respondent.
For what?
For this in the allegations raised in the petitions.
In this manner, sir. Why should we issue notices? You are complaining that there is misappropriation, corruption in the government schemes. File a complaint.
No.
That is courts is available to you.
So this honorable court may issue a direction to the CM Vigilance to register a case. This is what one of my prayers.
Sorry to say, tomorrow you'll ask, the court may go and arrest those persons. That is, if they have not, they'll not registered, then the whole mechanism is there in the CRPC.
Mr. Borua,
Yeah.
what my lord, the Honorable Chief Justice is saying is not about the correctness of your allegation. What is being said is that there are other mechanisms prescribed by the law. You have to avail those. Writ court is not meant for these purposes. If there are allegations of a commission of cognizable offense, fraud, corruption, there are mechanisms under the law. If you are not aware of it, you can seek help from someone. But these are not matters today. The writ court will not direct investigation because we are the final court. We cannot express any opinion at this stage. You approach the magistrate, file a complaint, and then automatically the legal process will start unfolding. If there is any grievance in that process, then you have the remedy of coming to the High Court, but not at this stage. Now, if the High Court says anything, then this is the final court in Northeast. After that, there will be a prejudice. If you dismiss your petition, it is over for you. If we pass a direction, then all courts and tribunals will fall in line. So this is not the right forum. You withdraw your PIL, approach the correct forum. That's all that is being said.
No, notices may be issued, my lord. My prayer is that to the respondents to this one. Otherwise, if it is allowed to go, they will be emboldened. The officers will be emboldened, and my company should be more encouraged to this one. That's why notices, my prayer is this. I'm not favoring withdrawing the petition, my lord.
FIR has been already registered, Mr. Chaudhary.
Not registered.
Lordship, from the pleadings and in Annex 7, page 138, Lordship.
138.
138, Lordship. It doesn't appear that FIR has been erased at Lordship.
In this.
The only, this is the application, not the FIR.
And the petitioner was never called for evacuation for this. I have never.
And page 131 also before the CM vigilance cell also.
What action has been taken?
Okay.
130.
130.
No. With respect to all I'm saying is, it is finish with the finish with the vehicle. Understand? That's what they did.
Yeah. This petition is filed by the petitioner essentially. By the petitioner in the design of public interest petition essentially raising a concern that there is a rampant corruption in implementation of the government, central government funded schemes such as Pradhan Mantri kaun si, which is that? Names of the schemes.
Pradhan Mantri Krishi Sanchay Yojana, PMKSY, par drops more crops.
Pradhan Mantri
Krishi Sanchay Yojana.
Sinchai
Yojana.
dash per drop more crop, comma, bracket में PMKSY dash PDMC. It is the case of the petitioner that though in respect of the corruption activities in which the government officials and the private entities are involved, he has already moved. He has already approached Honorable the Chief Minister of the Assam
And Chief Minister Business, SP of Chief Minister.
the Chief Minister of the Assam and to the Superintendent of Police, Chief Minister Vigilance Cell Assam, as well as the SHO, officer in charge of Megong Police, Meong Police Station. By moving, by submitting an application for registration of the FIR, but nothing has been done by the respondent government, the respondent government, and therefore a writ be issued to the respondents to initiate proceedings against the corrupt officials as well as the other persons involved in corruption in implementation of the above referred schemes. Full stop. Having heard the learned concepts of the petitioner and after going through the material available on record, we are of the view that if the petitioner is complaining about a commission, about commission of a cognizable offense and his attempt to register an FIR with the police has not been rectified, it is always open for the petitioner to file appropriate complaints before the concerned judicial magistrate as per the provisions of section 156 CRPC. Full stop. In view of the CRPC. Full stop. So far as regarding the allegations leveled by the petitioner in this writ petition, we are of the firm view that this court is not equipped with the equipped for conducting an inquiry into the allegations regarding corruption in the government schemes, and the proper course for the petitioner is to approach the criminal court for registration of a criminal case regarding the commission of a cognizable offense. With these observations, in view of the above, we don't find any good ground for issuing a writ of mandamus, hence this petition is dismissed.
Item 23.
May I please, Lordship, in this matter, I am being led by Senior Counsel Mr. P.K. Goswami. Lordship, there was some amount of delay on my part in applying for the VC, Lordship. Therefore, we could not get VC today, Lordship. I can you pray for adjournment for today, Lordship, so that we can apply for VC.
Then at the request of land council for the petitioner adjourn. Matter is adjourned.
Item 24.
I pray for some time to file reply to respondent 7 affidavit. Respondent 7 has filed one affidavit, my lord. So that I want to, my lord, file my rejoinder.
Yeah, then concept of the petitioner place some time to file counter to the reply of the respondents. Time paid for in granted list and for so.
Another 4 weeks time maybe done.
4 weeks.
Item 28.
Your lordship, paying for Passover matter for today, your lordship.
The request of
Yes,
the appellant. Is this matter of front, sir?
Not filed affidavit. Lordship, we have received the RTI information, but that is not in favor of us, lordship, and that is already submitted by the APSC department, lordship.
Not in favor of us then. So. Okay.
Also bless
ये information now can you take a That could be favor in either of the parties. It is information. Favor or disfavor, where is the question of favor or disfavor? Yes.
Okay. In that case, Lordship,
Next.
I will file it, Lordship. Much appreciated.
Item 29.
My lord, in this case, my lord, we prefer this appeal against the order of the honorable single judge. Now, lordship will find at page 44, my lord. Now, basic grievances listed, my lord, my service was provincialized, my lord, under the provision of, my lord, the 2017 Act, my lord. Assailing my provincialization, my lord, the respondent number 6 herein preferred this writ petition before the honorable single judge. Now, my lord, the honorable single judge by the order dated lordship will find it at page 45, start from page 45, my lord. On the ground that he is senior to me, belongs to, my lord, the language stream. 46 is the operating part, my lord. In view of section 14 of the so-and-so repository provision of the S provided therein. So the writ petitioner was related to the, my lord, the appellate provision until a decision is taken by the appellate authority, the effect of the provision shall not be given to the respondent number 6 till final disposal of the appeal, my lord.
The court has already stated that they.
Yes, my lord. Now, my humble submission as a officers of the court, my lord, I should take with your lordship that, my lord, for purpose of determination of all these issues, my lordship is also you a special bench has been constituted to look into the property of section 3111, my lord, of the act. What should be the criteria, whether it is seniority or not, because there is an indication in the act itself. And by Honorable Mr. Justice Sham and Mr. Justice Eddie Chaudhary, my lord. My lord is ever of this. And Mr. My learned friend also appeared in those cases. So this matter may be lordship.
वो सारे मिलकर पंच करते हैं
दिलू तो था ती वैल्यू है चलो
तो इसमें स्टे बेंच में लगा देता
तो मैं भी नोट कर सुआ
Anybody for the private response?
No, my lord.
The delay was condoned because the private respondent did not appear even.
And my
despite
lord,
notice.
we have also affected though he refused to accept the notice.
I appear for the department.
Notices have already been issued.
Yes. And he refused to accept the notice, my lord. He filed an affidavit to that effect. We are directed to take justice service also. We tried, but
Should it go before the special bench?
My lord, if I may just suggest, my lord, these issues of whether who is the senior or who is not, who should have been considered is a matter which goes before the educational tribunal. But if this order is modified to the extent allowing the respondent number 6 to approach the education tribunal, the appropriate department, and this his provincialization in the meantime need not be interfered with. But he approaches the tribunal, my lord, he'll have he gets whatever
The
results
court
he
has
gets.
already passed an order of this.
Staying the operation.
Staying the operation.
My lord, yes. His grievances, his provincialization has been interfered.
If the justice is asked you whether it can be referred to that bench or not, or there is no requirement for that.
Well, the rule was never under challenge. There, the provisions of law are under challenge. And that is what I'm trying to point out. That bench looks into the rule provision.
Having heard the land council for the parties, we deem it appropriate to admit this writ petition, hence admit appeal, admit this appeal, hence admit issue notice to the respondents, Mr. Kedas Mr.
R. Mazumdar.
Mazumdar is appearing on behalf of the respondent, official respondents number 125. Let notice of admission be issued to the respondent number 6, returnable on so and so. The interim order passed by this court on 25th of August 2023 is made absolute. Is made absolute.
Item 30.
Please, Lordship. Lordship, the learned single judge ignoring the well principle of law about the primacy of the judicial order over executive order in instruction. Overlooking the fact that, Lordship, that there is a judicial order about the continuation of the ADC till the decision is taken in terms of the direction given in the judgment. Lordship held the view that the Lordship, since the ADC term is expired, writ petition appellant cannot invoke Rule 9. Therefore, held the Lordship that there is no any material to show that Lordship writ appellant was ever elected as vice chairperson of the ADC Ukrumala, which is not correct as per the record. The Lordship, the briefly Lordship, if I may permit to say, Lordship, that the ADC term is 5 years. And starting from 2015, Lordship is expired in 2020. 2020 June, my lord. Then under section 13, Lordship, the term is extendable by 1 year. And the Lordship, the 1 year, instead of 1 year, 6 months was extended. And the COVID pandemic comes, Lordship. And the Lordship, the ADC, all ADC approached the authority that it is not feasible to hold election during the pandemic. They requested to extend the term, my lord. And instead of doing that, Lordship, that it appears that without consulting the Hill Area Committee, it appears that without taking the decision with the consultation of the Hill Area Committee, Lordship, decision was taken that it should not be extended, and that was challenged. And in challenge, Lordship, interim order was passed on 27 November 2021. To the extent that the Lordship, the 2020, to the extent that Lordship, the state government shall issue notice extending the term of the ADC. And the Lordship, instead of complying with the order of the court, my lord, a supersession order of the ADC was issued on 30 November 2020. That was challenged. That two writ petition was heard together. There was the interim order operating. And the final Lordship, by common judgment order, 2nd March 2021, Lordship, writ petition was disposed of by giving 5 directions. One of the directions is, Lordship, to continue the interim order. Tell the Lordship the direction, other directions are complied with by the authority. And direction includes, Lordship, holding of the election. That never comes, Lordship. That interim order is subsisting as on today, Lordship. And it is indicated by subsequent order in writ appeal filed by the state government, where no stay order is there, that the interim order will continue till notification for election is order is notified. That latest order was on 19 December 2023, Lordship. And the Lordship, the appointment to the post of chairperson and the vice chairperson is only by of election, my lord, not by any other, Lordship. And the Lordship, the election to the post of chairperson in terms of Rule 3 of the this rule, Lordship, it is to be conducted by the state government. And in the case of vice chairperson, it is to be done by the ADC itself. And the Lordship, present appellant, Lordship petitioner, was elected as vice chairperson. And the Lordship, even though there was an interim order, the order subsisting, Lordship, the government issued an order allowing all the chairperson to act as the acting chairperson, Lordship, caretaker chairperson. And the Lordship, accordingly, Lordship, all the ADC was functioning. And the Lordship, after that order, Lordship, the chairperson of the Ukul ADC resigned in June. The resignation was accepted in last part of this June, Lordship. And however, state government by decision the cabinet rolled back the earlier order of allowing the chairperson to act as the acting chairperson. That was challenged. And the Lordship, the only writ petition was disposed of, saying that till notification is issued, then the chairperson, that early arrangements shall continue. Lordship, in purported compliance of that order, Lordship, the private respondent, who is merely a member of the ADC, not vice chairperson, was appointed as acting chairperson, caretaker chairperson. That was challenged before the learned single judge, my lord. Learned single judge, Lordship, having perused the Rule 9, was pleased to pass an interim order on 3rd April 2023, Lordship. And it was heard, and ultimately, Lordship, then the Lordship, the learned single judge, by holding that, Lordship, that the ADC terms having been expired, Rule 9 can be invoked by the writ petitioner in as much as, Lordship, there is no any material to show that present petitioner appellant was ever elected as a vice chairperson, Lordship. Just may I take my lord to page, Lordship, page 63. Page 63 of the portion of the impeachment judgment. What does it say, my lord? Page 63. Lordship, we may read page 63, it is a short paragraph. The petitioner was also members of Autonomous District Council Ukhrul in terms of the election of the Autonomous District Council Ukhrul, but he was never appointed as vice chairperson of ADC Ukhrul. Letter issued by the Chief Executive Officer, Autonomous District Council Ukhrul, dated 21/12/2017, is a mere letter communication between the CEO ADC Ukhrul and the Principal Secretary TND Hills, Government Manager. And it cannot be taken that he had been appointed the vice chairperson by law. Then again, Lordship, referring back to paragraph number, Lordship, page number 20, page number 60, my lord. Page number 60. Paragraph number 25, my lord. As stated supra, Rule 9 contemplates the manner if the office of the chairman is lying vacant, the vice chairman has to perform the duty of the office of the chairman of such council. However, it is the say of the learned government advocate that Rule 9 will be attracted while the said Autonomous District Council was in existence. But the instant case, as the term of the Autonomous District Council Ukhrul has already expired in the month of June 2020, and after the expiry of the extension period, the petitioner is no longer holding the post of vice chairman, and therefore he cannot seek Rule number 9, Lordship. Then para 26 further says that, Lordship, it is a state policy and in compliance of the order passed by the court in various writ petitions, is that government issued the order dated 27/3/2023, allowing the private respondent number 4, Mark Luitan, to function as the caretaker chairman under the Autonomous District Council, Lordship. In the Lordship, the Ukhrul District Autonomous Council, there are 24 members, Lordship. Chairman, in terms of section 23, they are to be elected from amongst the member. So also the vice chairman. Only the Lordship, the method of election is different. In the case of chairman, it has to be done by the state government, notification has to be issued by the government. But in the case of vice chairman, Lordship, then it has to be done by the ADC, Lordship. That's may I take my Lordship, that's that particular rule, which I refer to, Lordship. Page 14 of the report, I reproduce my lord. I have submitted the rules and the act during my last submission before the Justice Mehta. It might be on record, my lord. But anyway, may I take my lord to page number 12?
Page number?
Page number, Lordship, page number 14. Page number 14. Election of chairman by council.
Number 14.
Election of chairman by council. The election of chairman shall be held on such that as the governor may fix and the secretary shall send to every member notice of this death. Before the election of a chairman, the governor shall appoint a member of the council who does not intend to contest the election to preside at the meeting. That is, Lordship, the chairman. Then election of vice chairman, Rule 4, my lord. The election of a vice chairman shall be held on such that the chairman may fix and the secretary shall send to every member notice of this death. So after the election is held, Lordship, it has to be communicated to the government. It was done by the CEO, but learned single judge said it is a mere communication, Lordship. And the Lordship, if I may be allowed to take Lordship to page number 68.
So, Mr. Pownam?
Yes.
You are assailing the judgment of the learned single judge.
Right.
Can you please show us what is wrong with the judgment first?
Yes, it is
Let's
wrong.
Start with that.
Two reasons, my lord. Learned single judge lordship come to the conclusion on the wrong premises that the lordship ADC term has expired, and therefore Rule 9 cannot be made applicable. Number one. Number two, what he says, the lordship, that the petitioner was never appointed as a vice chairman, and therefore invoking Rule 9, under which lordship, whenever the chairperson is not there, vice chairman has to assume the charge of the chairman. That is not applicable. Number three, what he says, the lordship, the state government in its discretion, lordship has the authority to appoint a chairperson, caretaker chairperson. But under the act and the rule, lordship, there is no provision empowering the state government such a power. It is a democratic institution, lordship. Whether the chief minister, caretaker chief minister can be appointed by an executive order, my lord. Whether the mayor can be appointed by the executive order unless there is an election. So is the same case, lordship.
No, but until such time an election is held.
No, lordship,
How
may
is
I
it
take
body-
my lord to
body
the order of the High Court, my lord. May I take my lord to case number
Yes.
starting from page number 110. 110. There are three representations hard together, my lord. And the first, I take my lord to page number 100 and 118. Lordship. 118, paragraph number 4. On 27/11/2020, when writ petition came up for consideration, this court filed issuing notice to the respondents passed an interim order directing that term of the district council in respect of the hill area be extended till 4/12/2020, for which state government should issue necessary order. After reading this, lordship, may I just for a minute, lordship, the case number 140. 140. About 6 lines from bottom, my lord. About 6 lines from bottom, lordship found it on top of that. Lordship found it. On top of that, it may be noted that on 27/11/2020, when writ petition being WPC number 613 of 2020 came up for consideration, this court passed an interim order directing that term of the district council be extended till 4/12/2020, and that a necessary order should be issued accordingly. Instead of issuing any order extending the term as till so, the interim order was issued superseding the district council, which is contrary to the interim order dated 27/11/2020 passed by this court. In other words, the interim order which was violated the interim order of this court is bad in law, and it's being unsustainable is liable to.
1 minute.
Yes. Excellent, sir. Good. Brother, see you. This is order.
Now, who is at present, as per this judgment, who is working as a chairman? Who is discharging the duties of chairman?
Lordship, since after the writ petition is dismissed, even though there was an interim order before the disposal, Lordship. Private respondent at the moment is functioning.
Private respondent is the member of that executive.
Lordship, he is a member of the ADC, but he was never appointed as vice chairperson.
Never appointed by
As a vice chairperson.
vice chairman, that's another thing.
Vice chairman, Lordship, vice chairman can be, yes. Lordship, appointment to the post of vice chairman.
Member of that executive.
No, not executive, Lordship. Member of the ADC. Member, Lordship, and the executive member, and the vice chairman, the chairman, there are different things. The chairman and the vice chairman are only by way of election amongst themselves, Lordship. Chairman is by way of election. Vice chairman is also by way election. Lordship, how the authority pick up a member who was never acted or functioned or elected as vice chairperson?
That is absolutely, that is not our concern.
Yes, that will be the point of consideration before this court, Lordship. May I take my lord to the impugned order, which I challenge before the learned single judge, Lordship. Lordship, that is at my lord.
Just a minute.
Yes.
Mr. Pownam.
Rule 9.
Mr. Additional AG, you are appearing in this case. All right, we just wanted to understand one thing.
Yes.
The term of the earlier committee council has already expired.
In 2020.
Yes, and even the extended period is over.
Yes, 2021.
So the election of all the members of the council
Yes.
have came to an end.
Yes.
Nobody is today can be counted
Yes.
as a member of the council.
Yes.
And you have not conducted any fresh elections.
Yes, we was about to.
Just a minute.
No, I just want to communicate that. We was about to hold the election.
Yeah.
The problem is there's a situation happening in Manipur.
All right, all right. So under the circumstances, it is a government functionary who has to run the affairs of the council.
That's
How
what-
can you choose either him or her?
No.
None of them have any.
Because for this, especially for this Ukhrul district, my lord,
Hmm.
after the resignation of the earlier chairman who was taking as a caretaker, my lord, he resigned in 2022 in the month of June, my lord. Then the resignation was accepted in the last part of the June itself, my lord. From June to in the next appointment, the present petitioner, he has not claimed that I should become a caretaker. He has not claimed, my lord. That is a stoppage matter. Then, because of that, the government issued one order in the year 2020 in the month of August, my lord. My lord, I'll just take that order.
No, we understand. Our query is
No, no.
slightly different.
What happened is that why? In the month of August, we have issued another order saying that we are discontinue all the caretakers, my lord. And some person again challenged the before the court, saying that this cannot be done. So they have taken the stay order, my lord.
In which proceeding?
This page number, kindly see page number 140.
Lordship, I haven't completed, that's why, Lordship. Even Lordship.
Just a minute.
Yes.
We'll hear you.
Ascertain the facts. We
Yes.
are not hearing.
My lord, kindly come to page number 146. On 4 August 2022, my lord. We have discontinued all this caretaker chairman, my lord, system and autonomous district council. And they challenged by some other person, my lord. Those who are not, I mean, the terms has already expired. By taking the judgment of the earlier common judgment passed in the 613, saying that we should continue, my lord. So because of that, this order was stayed. And subsequently, my lord, kindly come to page number 147. There's
This
another-
proceeding is now pending before the High Court.
Yes, appeal is pending, my lord. And but the state government, my lord, we have to fill up. No.
Just a minute. It's by proposed discontinued with all caretaker. Caretaker chairman system. Cancel the caretaker chairman system. Discontinue with. किसी ने legal instructor caretaker has to continue. So we are non-committed.
Give us a copy of this Manipur Hill District Council Act 1971.
So I think it might be in the paper book, in the file. I have already submitted, again the rule. I can roll and go through. Roll nine.
You see, I think that. I don't think. Chairman needed to vice chairman. उसके अंदर तो अभी but you see where the body is dissolved. In case the council is dissolved,
or its term ends prematurely, who runs the affairs of the council till the fresh elections are held?
Normally, my lord, government has a discretion to appoint, my lord.
No. Under what provision?
Because as party, my lord.
As per which provision?
Yes, my lord, kindly speak in terms of the section 47, my lord.
Section 47.
But the other case, my lord, what happened is that before the completion of the one term, my lord, the government has, removed all the caretaker. Because of that challenge, because the provision has provided for 1 year extension. So government has not done it. Because of that, only judgment was passed. That the 613. The Lens was taking that. So that is not connected because this case is after the expiry. That case was filed before the expiry of 1 year, which is provided under the section 13. My lord, the 47D, situation has arisen in which the administration of any district council cannot be carried on in accordance with the provision of this act. The administrator may by an order published together with a statement of reason therefore in official periods to persist such council for such period. Not exceeding warrior has made this prescribed in the order.
So yeah, answer here, 47. 7 B. 7 B. Well, they will have to check it. We pointed out, which may. So the definition of administrator has now changed. It was earlier union territory.
Yes.
It says the administrator of the union territory. But now who is the administrator? The governor?
My lord, now that is deputy commissioner will do.
No, not deputy captain, government. Administrator is the government, it's the government.
Government.
Yes. The deputy commissioner has no role, man.
Whatever it may be, whatever the authority may be,
Yes, ma'am.
suppose we come to the conclusion that he cannot claim
Yes.
to be appointed as caretaker vice chairman since his term has already expired.
Yes, madam.
Under what provision you can appoint a member of that executive council whose term has also been expired
Yes.
as a caretaker?
By taking my lord, kindly take to the order issued by the government in page number 158.
158.
Yes.
Yes.
Para 1, my lord.
Yes.
Whereas the Tribal Affairs and Hill Department, that is 14 March 2023. My lord, before this, I'll take to 157, my lord.
Yes.
Whereas the Honorable High Court order, so on, pass the following order direction. A, the present writ petition are disposed of. B, interim order granted by this court on so on, should continue till the issuance of the notification for the election of ULBs and Autonomous District Council. 2, whereas Administrative Department of Tribal Affairs and Hill South, Command of Law Department and so on, the learned Advocate General advised that the order dated 4/11/2022 and 19/1/2023 of the Honorable High Court have not been stayed or modified by the higher forum of the Honorable High Court or Supreme Court, and such administrative department will have to honor the said Honorable High Court order to avoid the legal complication, including contempt of court. 3. In view of the above, the Honorable Governor of Manipur is pleased to allow the last constituted caretaker, Chairman of the Autonomous District Council, concerned to function as a caretaker chairman till the issuance of the notification for the election of Autonomous District Council, Manipur, my lord. Then next page, on 27 March, my lord. Since in the Ukhrul district, my lord, since after the resignation of the chairman, my lord, caretaker chairman, there was no person holding after the resignation, my lord. So the government has decided among the members who are elected. So Mr. Prior Respondent number 4 was chosen to be as a caretaker, my lord.
Under what provision, sir? Which provision?
Uh,
Under which provision you can choose this respondent number 4 who is member of the executive council? Then why you are not given this to vice chairman?
No, because if the vice chairman, because he was not declaring that he should become after the resignation, my lord. But he has not
chosen a person out of how many members are there in the executive council?
24, my lord.
24 out of 24.
Yes, only
What
one
is
has.
special about this respondent number 4 that you have chosen him? And under which provision of the
No,
law, sir?
because after, my lord, after considering all this aspect, then we can come to know that this person, my lord, he was having one affair, my lord.
Just wanted to know from you,
Yes, my lord.
you have a chairman,
Yes,
correct? A chairman would arise when there is a council. He has
Yes.
to chair something.
Yes, my lord.
But the term of the earlier members have all expired.
Yes, my lord.
Have you extended their terms?
It was expanded for 1 year.
Till-
Because of the court order.
Whatever.
Yes.
Till which date?
It was extended till the last part. That is in terms of the court order, my lord. Because the court has clearly mentioned, my lord.
So he is chairing a meeting of, who are the councillors that he's chairing? There has to be a council to chair, have a
Till that
chairman.
Mr. Yang Lung was chairing till the resignation, my lord. Till the resignation.
Please understand the question.
Yes.
If you want to have a chairman,
Yes.
then you have to have a body of members. Then only there is a chairman.
Yes.
Correct?
Yes.
So that body has to be the elected members of the council.
Yes.
Then these members elect a chairman.
Yes.
But all of this will be possible as long as the term of the body survives.
Yes, my lord.
Once the term expires, there is neither any member and consequently there is no question of any chairman.
Yes, my lord.
Then the administration of the council has to be taken over by the government. And the government has to appoint an officer
Yes.
to look after the affairs
Yes.
till such time an elected body comes back in power. So today you don't have an elected body, you cannot hold elections. Where is the question of appointing a member as the chairman?
No,
Because you don't have a council today.
Because the court has given a direction. My locality.
Where is the direction?
Yes, that's what.
Appoint the respondent number 4.
No, my lord. Kindly come to the judgment passed in the 613. The page number, my lord. Page number 141. Para 17, my lord. There are certain condition has been directed, my lord. Page 141, my lord. Para 17.
Yes.
Page 141, para 17, my lord. Because of this, our state governments are very.
Where is that?
For the reasons stated here above, the writ petition being then disposed of with the observation made here above, so on, so on. A,
The state government and its particular the Additional Chief Secretary T.N. Hills, Government of Manipur, shall write a letter to the Hill Area Committee, Manipur Legislative Assembly, seeking its opinion as to whether the term of the district council shall be extended or not till the completion of the election, and the said letter shall be written within a week from the date of receipt of copy of this judgment and order. B. On receipt of such a letter from the Additional Chief Secretary T.N. Hills, Government of Manipur, the Hill Area Committee, Manipur Legislative Assembly shall furnish its opinion within a week from the date of receipt of the letter. C. After the opinion of the Hill Area Committee, Manipur Legislative Assembly being duly received, the state government shall take a decision to issue an appropriate order immediately in terms thereof. D. Till such an order issued by the state government as mentioned in the direction C above, the interim order dated 27/11/2020 passed by this court shall continue, my lord. E. The State Election Commission, Lamphel Manipur is directed to announce the date on which the election of district councils shall be held within a week from the date of receipt of copy of this judgment. So in terms of this D, my lord, they have been continuing, my lord.
This 27/11/2020 interim order,
Yes, my lord.
where is that?
It is annexed, my lord. No, Lord, it is not annexed, my lord. It is recorded the para 4 of the judgment.
Para 4 of the
Yes,
judgment.
madam. Which I have already taken, page 119.
Para 4 of this judgment or?
Of this same judgment which my learned friend is reading, page 119, madam.
119.
18. As per the judicial order, Lordship, District Council is deemed to be functioning, madam.
On when the restriction came up for consideration, right, issuing of the pass and interim order affecting the term of extended. This 118. Para 118, page 118 you are referring to?
Page 118. Para 4,
118
it is this is what's referring to at paragraph number.
on 27/11/2000,
yes.
when the writ petition came up for consideration, this court, while issuing notices to the respondents, passed an interim order directing the term of the district council in respect of the hill areas be extended up to 4/12/2020.
Right.
For which the state government should issue necessary orders.
Lordship, that order has never been issued. Instead of that, Lordship, they issue an order in exercise the power under section 47, superseding the district council, madam. That was challenged. That was challenged. And that has been was set aside as reflected at para number 25. So section 47 is nothing but for supersession, madam. State government is not given any power.
Elected body where the government will hold election and then.
Mr. Advocate General.
Yes, ma'am.
Whatever it may be, certainly you have some point in doing that. This appellant has no, as a matter of right, cannot claim to be to remain as chairman.
Yes.
Once his term is expired.
Yes, madam.
But so far as regarding respondent number 4, at present is working as the chairman. That is also not acceptable in any manner. You complete your instructions, either will not allow either the appellant or the respondent number 4 to continue as the chairman of the district council, autonomous council. You either you appoint a government official.
Yes, that madam.
You appointed.
Yes.
Or seek your instructions in that.
Yes, madam. Because we was almost appointed
after discontinuing all the autonomous district council caretaker, some person again went to the court saying that this is against the judgment passed by the division bench, single bench, that the common judgment, which I just read out. So they are, I mean, filing one after another, my lord. So
Who is appealing for the respondent number 4? Your right to be remain as a chairman of this autonomous council?
Your lordship point is absolutely correct. But when the earlier caretaker chairman resigned from his post on 6th of June 2022, the present attorney did silence. He never claimed that as I was the vice chairman.
No doubt, no doubt. No doubt about it.
As I was the vice chairman, I should be appointed as a caretaker chairman. He remained silent, my lord, for nearly 9 months, my lord. Only as a way, as a matter of policy of the government, when the respondent number 4 was given as a caretaker chairman, he wake up from slumber. And by raising so many grounds and things, in fact, the profile of appropriate and inappropriate is a project activity.
Mr. Concept, you have to answer, what is your right to be continued as a chairman of this autonomous council? What is your right to be continued, except that the government has appointed you, but government has no justification for your appointment?
Just for administrative convenience and also just
Vacated.
ABC functioning, my lord, I was given the start of the.
27
chairman.
has been vacated.
It's a matter of policy.
This interim order of 27/11/2020 has already been vacated.
Not vacated, ma'am. It is lordship will continue till election notification is issued.
it was merged.
It has been vacated, sir, this on
No,
19/12/2023 order.
No, lordship, it says that lordship, 19 December 2023. It says that lordship,
Upon the said election.
yes,
Yes.
announcing that upon the said election commission announcing so and so, interim order shall stand vacated automatically. That notification is not yet issued, madam.
Yet issued.
Yeah.
But in any way, you can't continue this respondent number 4 as chairman.
If the government, if the court gives a liberty for appointment of from the government side, then I have no issue because they will be challenging again.
No, Lord,
Otherwise,
Will direct?
yes.
lordship,
Instruction at-
may I just assess lordship?
Yes.
Under the ADC Act and the rule, lordship just peruse it. Where is any provision empowering the state government regarding the appointment of the chairperson or vice chairperson, leave alone lordship administrator, my lord? Because lordship, it is a democratic institution. Supposing the term is over, lordship, if election cannot be held, lordship, in the case of state lordship, present rule is there, lordship, but constitutional provision is there. But in the case of ADC lordship, there's neither constitutional provision, no provision in the ADC Act and the rule, lordship. And the lordship, one more submission, lordship.
So much, if you are too much
No.
pressing on the rules. and
No,
it's
no,
as
lordship,
well,
what I'm submitting,
your
lordship.
authority
No.
As per of you, so you are now a stranger.
No, I may I just submit, lordship.
With the expiry of your term.
No, lordship, I'm
you are now a
submitting.
stranger
I may be allowed
for
to
the
submit.
autonomous council,
Just
sir.
5 minutes, lordship, I will be allowed. Section 47 deals with superstition. It is not a power given the authority to make arrangement in the absence of any elected body, lordship. Superstition order issued on 13th November 2020, having been interfered with, lordship, against which the appeal has been filed. There is no stay order. Lordship, whether is that government issue order or not, by the judicial order, lordship, district autonomous council will be deemed to be functioning, lordship, deemed to be functioning. And lordship, I leave to the wisdom of the honorable court, but by the strict interpretation of the judgment rendered by the High Court, lordship, which is not stayed by any competent court, and the interim order will be subsist till notification for election notification is issued. Meaning thereby, lordship, as per the judicial order, it will be deemed to be functioning. And the lordship, this
They are not, they are simply.
no,
saying
I'm only highlighting. And then in the lordship, in the case of in the that very good. Lordship, in the case of Commissioner of Central Excise.
What is the position now? Is the autonomous council, the life of the body is extended or has it expired?
In terms of this court order, my lord, they are still.
If that is the
Because-
case, Lordship, I have a right.
But no, he has no.
I have a right.
He has.
Because if the ADC, no, if ADC is deemed to be functioning, Lordship, I have a right. I have a right. In terms of the Rule 9. In terms of the Rule 9, my lord. What the Rule 9 says, Lordship, just for a minute, Lordship.
After 4/12/2020.
Yes.
The term of this hill area, the district council of the has not been extended.
Because of the court order, my lord, they have been continuing.
Which court order?
For that only, my lord, I was showing that one document. My lord, kindly see. Yeah, it was extended. It was extended, my lord, kindly see the order in 27.
Not extended.
Okay.
Not
My lord,
extended.
kindly see.
Additional record person here. This shows it.
Not extended.
No, didn't to be continue. My lord, kindly see page number 146.
Only to we have to check that we get. Chairman, only take left. In the elections that we held by the state. In the case when COVID and the situation. It is happening that pending. Then we all the members has to elect. Actually, he is the vice chairman. Including the vice chairman, how do you elect a member? It's cutting the line. If the term of the body is expired, then it has to be the government.
My lord, I'll just clarify. one. Page number.
At two.
We'll continue.
My lord, when my lord was query about the provisions, I just want to read one order. It was issued in 2021. How this was the continue.
Learned single judges quoted all those orders, relevant orders.
This one is not quoted, my lord. Page number 140.
Okay, let us just a minute, please.
Yes.
Hold on.
वैसे नहीं ऑर्डर ऑर्डर यहाँ पे वैसे नहीं। Two, 2021. 2020. Yes. Yeah. Hmm. Yeah. Hmm. Yes, 22. Hmm. No understand. Yes, yes. Correct. Yes, 22. Hmm. Yes. Certification policy included in No, Kerala is not in the Western. He is not even the Western. The parent is right. A appointed or B appointed. It is right. Something. Yes, madam. The learned single judge has recorded a finding that you have never been appointed as vice chairman.
Yes, I recorded. May I take my lord to
Para 29.
para 29.
Para 29.
Right. And the lordship, may I take my lord to page number 107.
107.
Yes. It is the lordship, the election of the present appellant as vice chairperson was communicated to the state government by the chief executive officer. Number one. Number two, my lord, court said this document was not on record. But if lordship may kindly type, lordship kindly refer to page 68. Page 68 again. Page 68. That is the certificate for election of the present appellant as vice chairperson.
Annexure
Annexure W3, page 63.
63.
Yes, 68. I'm sorry, 68.
Certificate of election.
Yes. And again, lordship,
This was not produced before the Learned Single.
yes, but the other one, the page 107 was there. And again, lordship, if lordship may kindly refer to page 89, Peratin. Page 89,
89.
Peratin. That is the statement made by the present appellant in the writ petition, my lord.
89, yes.
Yes. The following the constitution of new autonomous district council in accordance with the provision of so and so, one so and so from Ringwing village of Okrul Autonomous District Council Okrul was elected as chairman. Subsequently, present petitioner was also elected as vice chairman of the Okrul Autonomous District Council Okrul, which can be substantiated from the letter dated so and so, so and so. Thereafter, Okrul Autonomous District Council Okrul has started its function to carry out its public duty as required and expected from such institution. This statement made in the writ petition is not controverted by the respondent. May I take my lord to page 160, page 162. Counter affidavit filed by the private respondent. State government. Yes, page 162.
Yes. Deponent comments.
Yes.
Answering deponent, there is no comments. to-
Paragraph number 10. Lordship, they add para number 4. That reference to para 10 of the writ petition. The answering deponent has no comment to offer. That was not
Has no
controverted.
comment me as comment to offer.
Yes. And again, respondent number 4 also, if lordship may kindly turn to page 179. 79. 179. It is now the case of the respondent. And again, lordship, if lordship can come to page,
That's to submit when this.
page 169, private respondents counter,
179,
169.
169.
Yes. private respondent of force counter affidavit.
Yes,
Page 6, there are the paragraph number 5.
there's nothing to say.
Yes, ma'am. And the Lordship, it is not the case of the respondents, the Lordship.
Mr. Advocate General and counsel for the respondent, you are disputing that he was not the vice chairman of the
Yes, my lord.
council.
To be very frank, when we filed the evidential position, but we did not deny his letter, my lord. But later on, my lord, when we inquired, doesn't found that there is no such an order for appointing him as the vice chairman. So at the time of hearing, we can pass our solution that there is.
What about this 68? Page number 68, annexure W3.
My lord, I just want
This
to,
is a certificate of election.
my lord, I just want to clarify.
No, but it is there.
No, my lord, so far as this administrative order, my lord, after the election, my lord, at least the government has to issue one order saying that such and such person should be appointed as a vice chairman.
This certificate,
Certificate has to be communicated to the government. This is the only certificate issued.
certificate is there.
Certificate is only for the issue by the RO, my lord.
Can he be deprived of this fact that communication you are not sent to the government, therefore
But as
he
per
can't be treated as a
the,
vice chairman. It
but
seems that this finding of the Leonard Single judge is perverse.
but as per the rule A of the this autonomous district council, if any vacancy or anything, that has to be notified by the government, my lord.
So even though he was not elected as a vice chairman at any point of time.
Yes.
Have you, the government has taken or the authorities concerned has taken any steps to fill that post? You mean to say that nobody was chairman, was appointed as a vice chairman at that point of time?
No, vice chairman has to be elected from the amongst the member.
That is, this is what the certificate of election.
That is only just now produced, my lord.
Maybe it is there.
But my lord, the issue involved in this is that after the expiry of the term, my lord, whether he can be continued as a vice.
How respondent number 4 can be continued?
No, but
Here the question comes.
that is what we are coming from the, in terms of this. That is what I just want to, after the judgment passed by the single judge in common order, then we have issued one order in terms of this disaster management, since the provision has been silent for appointing any caretaker. Well, I'll just take to page number 143.
What?
143. 143.
Yes.
17 May 2021.
Page marker.
After the court order, my. In superstition of the previous government, my lord was asking
Yes.
whether there was any extension or not. In superstition of the previous government order, also dated 30/11/2020, and in consideration of the recommendation of the State Executive Committee, Relief and Disaster Management Department, the Governor of Manipur is pleased to appoint all the existing chairmen of the Autonomous District Council as a caretaker chairman. This is an interim measure till the election of the Autonomous District Council are held. The caretaker chairman shall not exercise any financial power and shall look after the normal routine duties of the council. Further, the Deputy Commissioner and Chief Executive Officer concerned of the district shall be the joint signatories for all financial transactions of the council. This order was never challenged by any of the caretakers, my lord, or existing members, my lord. Then after issuing this order only, after the 6 months, this ADC chairman, who is taking as a caretaker, submitted his resignation on 6 June 2000. That is not that. That is what, my lord. After the acceptance of the resignation, the person who is claiming that I should be the caretaker of the chairman, he was a silent, my lord. He was not taking any relief from the government or submitting any letter that I should assume as a caretaker. Ultimately, in terms of the section 29, for the work executed for the members in the ADC, my lord. So government has taken a decision, my lord, as a government policy to appoint a member from the ADC Ukud to represent as a caretaker, my lord. Taking the section 23 from 1 month.
ये और जो है ना, chairman was appointed and he declined. Then by virtue of rule 9, it has to go to the election. Second, they- we- executive council is such. It's complete. It's from death. The chairman. It's the chairman. Commercial. It's not a matter, दूसरे और नहीं। देखते ये very honest है। ये consider it.
Yes.
Lordship, my learned friend was saying that, Lordship, there was an election. Certificate is there. That was on 20 December.
Yes,
Page-
that is there.
Yeah, page 107. That was 21st December 2017.
Yes.
That was communicated by the secretary of the
The
Council.
government.
That is there. And my learned friend saying that, Lordship, 17 May 2021, that ordered the allowing all the existing chairmen to function as caretaker chairman, Lordship. Because as I submitted earlier, it is one of the Lordship, the democratic institution. That's why, Lordship, any person from outside the ADC cannot be brought in as much as any member. That's why, Lordship, they're allowing the caretaker chairman. Another submission was made by my learned friend that it was this 17 May to 2021, the chairman resigned. That was on 6 June. That was accepted on 29 June, Lordship. And in the meantime, Lordship, process was underway for appointing this man as chairman. And however, Lordship, on 4th August, 1 month and 3 days, that order of 17 May was rolled back, Lordship. That is 4th August. That was challenged, and that was challenged on 19/1/2023. Then order was passed, allowing to continue till notification of the election is
To the
issued.
caretaker chairman.
Yes, and that is allowing. And in the meantime, after the order passed by the court was in the process of compliance, Lordship, it was complied, Lordship, only on. It was complied, my lord, by the state government. Yeah, sometime in the January. PLC Lordship 157, Annex 18. 157. 157. That was complied with by the state government on 14 March 2023, Lordship. After about 6 months. From August 4 till 13 March 2023, all the caretaker chairperson were not functioning, Lordship. And after this compliance, Lordship, there was also another process appointing this man as the caretaker chairman. Somehow, Lordship, on 27 March 2023, private respondent has been appointed, Lordship. Under what provision he is appointed by picking up from among the 24 was never be any vice chairperson elected or functioning as chairperson. He was saying that for 6 months, I remained silent. I did not remain silent because only one month and 3 days was available report. And after 27 March, Lordship, I approached the court. The court stayed this order. Court stayed this order in the first week of April, Lordship, 3rd April 2023. And the Lordship, the interim judgment was passed on that ground that I was never been appointed as chairperson. In as much as this order is a discretionary power of the state government. But Lordship, whether the act in the road provides any provision allowing the state government to act in this manner, my lord. In as much as Lordship, why, in what manner this man hasn't picked up? If they're going to pick up, Lordship, why not me? That is one question. Another thing is, Lordship, as I submitted earlier, the order judgment, the order common judgment, which was read out by my learned friend and some part by me. Direction part, there are 5 direction part, Lordship. One direction part, Lordship, to continue the interim order till decision is taken, Lordship. That was on 27/11/2021. Lordship, whether the state government comply or not, that is another thing. But so far, judicial order is a concern. All the district councils deemed to be functioning, Lordship. And the Lordship, that order is not stayed or modified by any higher court. And as I submitted the order passed on 19 December 2023, Lordship, that interim order will continue till election notification is notified. So, Lordship, it is subsisting. And the law in this regard is very clear, Lordship. In the Ravi Naik case, Lordship, para 40, it clearly says that, Lordship, what is the position, Lordship, whether the judgment is incompetent or otherwise, till it is altered, Lordship, it needs to be complied with. It needs to be adhered to. That is what Ravi Naik said, Lordship. And the Lordship, in another case, Lordship, primacy of the judicial order over the executive order, Lordship. Lordship, there is always a primacy of judicial order. How can state government, in excess of power, issue an executive order appointing this man as acting chairperson, Lordship? And the Lordship, one judgment, yes, I would like to cite, Lordship. Ravi Naik, Lordship, I'm submitting, and another judgment, Lordship, 2011. 2011, volume 13, SCC, page 180. Paragraph, Lordship, 112 and 25 to 30. I'm not reading, I'm not overburdening a Lordship. Primacy of judicial the judicial order passed by the High Court and the Supreme Court is emphasized, Lordship. Lordship, the tribunal passed an order for giving effect to this circular issue by the state government, by the authority. That was, Lordship, deprecated by the Supreme Court. Because there was already finding by the Supreme Court in that point regarding the interpretation of the meaning of the manufacturer model. Para 11, 12, 25, 26, 27, 28, 29, 30, Lordship. And therefore, Lordship, the district council in the state Manipur will be deemed to be functioning as per the judicial order. If that is so, Lordship, this man has a right. And the private respondent in the case doesn't have a right. His appointment is quite arbitrary. Why he was picked up? What is the manner and method they have followed, my lord? Ravi Naik, para 40, my lord. Para 40, I'm submitting the. Para 40, page 662, my lord. Just above para 41, about 6 line from bottom, Lordship. Para 40, just above para 41.
40.
Yes. It is settled law that an order, even though interim in nature, is binding till it is set aside by a competent court, it cannot be ignored on the ground that court which passed the order had no jurisdiction to pass the same. Whether the order of allowing to continue the Lordship District Council is illegal or otherwise, if it is considered due by a higher court, Lordship, that has to be complied with.
Yes.
And therefore, Lordship, I leave to the wisdom of the honorable court. But thing is that, Lordship, in a democratic institution, in any institution, starting from Lordship municipality, panchayat, or Lordship state assembly or MP, whether there is no provision empowering any other third party, any member to function as a caretaker chief minister, caretaker prime minister, caretaker president, Lordship. Panchayat and the municipality and the 6th scheduled district council, like in the state of Assam, there is a constitutional provision. District council in Manipur, Lordship, there is no any constitutional provision. It is a hybrid in between matter. There is any constitutional provision so far district council of Manipur is a concern. That is the unfortunate part, man. Is that government is not taking up any rectification measure to rectify it. That is the whole problem. If it is 6th scheduled, Lordship, it can be answered by law. And if it is municipality or panchayat, it can be answered. because that is a constitutional provision. But ADC in Manipur, Lordship, it is not governed by the any provision of the constitution. That is the unfortunate part. And the state government, as on today, it was enacted in 1971, and they are sleeping well. That is why the reason. There is any residuary clause in the whole act of the ADC Act. No residuary clause giving power to the state government, except power of supersession under section 47. And my learner was referring to section 29. What is section 29, Lordship? They said that order of 2021 is issued in exercise of power under section 29. That is wholly misconceived, Lordship, because section 29 says, the Lordship, section 29, what does it say? Subject to such exceptional condition as the administrator may make impose, the following matters shall be under the control and the administration of district council. Namely, so. Is there any power given to the state government? My lord. But my learned friend is submitting that 2021 order of allowing the existing chairperson as caretaker has been issued in action power in section 29. Law is here before, Lordship.
So State Election Commission is not a party in this appeal.
Lordship, in all the cases, I'm sorry, Lordship, they are not made party.
But not a party.
But State Election Commission, Lordship, in spite of the election, Lordship, there was a PL matter pending before the High Court of Manipur. And that was disposed of on the undertaking given by them. Election will be held in the early part of the 2023. Lordship has seen that during the pandemic, there was a Lok Sabha election in Manipur. That they could not hold election for the municipality, Nagar Panchayat, and district council as on today. I do not know what is the intention. And the Lordship will understand when the Honorable Court passed order, the emphasize about the requirement of the holding of the election. Even the writ petitioner, Lordship, one of the prize direct the authority to hold election. It is not that we do not want election. It is the authority who is not holding the election. In such circumstances, Lordship, whether they will allow to abuse the power given to them, that also in the absence of any provision empowering them to do so. More importantly, Lordship, what was the manner and the method, in what circumstances, by following what procedure, this man was picked up from 24%.
Already submitted.
Yeah, I'm not repeating, I'm sure. I said that I will not be overburdening a Lordship. I live entirely to a Lordship wisdom. But this is the case.
Yes. Anything else?
I just want to clarify why the election could not be held in the month of the December 2020, my lord. That I'll just clarify because it is off the record. The application has been submitted by all the ADC chairman saying that because of the COVID pandemic, my lord, the election may be deferred, my lord. Because of that, election was deferred, my lord. Election was deferred. And subsequently, then is about to issue this thing for the notification. Certain delimitation has to be done among the district council because some district has been inserted, my lord. There was only 6, then it has become 8 district councils are there. So whether that 2 has to be delimitized or not has to be done by the state government. We have taken the decision from the Hill Area Committee whether this 2 has to be excluded or whether the earlier 6 ADC has to be included. That has to be decided. Because of that, the election could not be held. And subsequently, my lord, this now incident is going on, my lord. Because of that, we could not hold the election. But we have already given the communication to the Hill Area Committee as well as to the Home Department to give the information whether election can be done or not. This is the situation in terms of the early division bench order passed in the Manipur High Court, my lord.
Yes.
I would like to have one important change.
And my lord was asking there whether instead of appointing this private respondent or the petitioner, my lord, the government, for holding this, taking the charge of the ADC, my lord. In that part, I'll take the instruction whether, because it's going to affect to the other 5 ADC council also, my lord.
Yes.
Present resolution number 4. The most important thing, my lord, here is that when the earlier caretaker chairman, my lord, resigned on 6th of June 2022, and his resignation was accepted on 27th of June 2022. The present appellant, who is the writ petitioner, he did not raise even a single voice that as I am the vice chairman, in view of Rule 9, I should be appointed as a caretaker chairman. He never raised any voice. He remained silent, my lord. And the meaning, and thereafter, only as and when the present respondent number 4 was appointed as a caretaker chairman as a policy of the government of Manipur on 27th of March 2023. He woke up from slumber and he has filed a present and a writ petition by raising so many grounds, and he challenged the appointment of the respondent number 4 as caretaker chairman of the ADC Ukrul. So, in this regard, my lord, I would like to humbly submit that his own conduct is barred by the principles of appropriate and reprobate, my lord, because he cannot blow a hot and cold in the same case. Once if he remains silent when his my lord, right is affected, then he cannot later on, my lord, by taking a U-turn, cannot raise so many points, my lord. In that regard, I would like to cite one judgment of the Honorable Supreme Court, if your lordship kindly permits me, my lord. That is, my lord, this is 2011, volume 5 SCC, page 435, my lord. That is Joint Action Committee Airline Pilots Association matter, my lord. 2011, volume 5 SCC, page 435, my lord. Page 435, relevant para is para 11 and 12, my lord.
Read.
Yes, ma'am. I have also given the list of book, ma'am. Yes, yes, ma'am. I did talk, ma'am. With the kind permission, I did talk, ma'am. Para 11, my lord. In RN Gosain versus Yaspal Dhir, this court observed is under law does not permit a person to both approbate and reprobate. This principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, and that a person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could only be entitled on the footing that it is valid, and then turn around and say it is void for the purpose of securing some other advantage. Then next para 12, my lord. The doctrine of election is based on the rule of estoppel. The principle that one cannot approbate and reprobate inheres in it. The doctrine of estoppel by election is one of the species of estoppels in vice or equitable estoppel, which is a rule in equity. By that law, a person may be precluded by his actions or conduct or silence, my lord, when it is his duty to speak, from asserting a right which he otherwise would have had. Taking inconsistencies by a party makes its conduct far from satisfactory. Further, the parties should not blow hot and cold by taking inconsistent stance and prolonged proceedings unnecessarily, my lord. In the present case also, my lord, when the earlier caretaker chairman resigns from his post, what he was doing, my lord? He could have raised that as I was the vice chairman, or as I'm the vice president, vice chairman, my lord, in view of Rule 9, I should be appointed as a caretaker vice chairman. He did not do it. He remained silent, my lord. So he is barred by the principles of estoppel in filing present writ petition. And in the writ petition also, my lord, when he questioned my appointment as a caretaker chairman, he never pleaded that under what facts and circumstances his right is affected, how he is aggrieved. Nowhere it is stated, except by saying that his fundamental rights is deprived of, my lord. So in fact, well, he is not an aggrieved person, my lord. And regarding my appointment, as rightly pointed out by our additional legend, that as a policy of the government of Manipur, I was rightly appointed as a caretaker chairman, my lord, till the election notification is issued, my lord.
Thank you.
So there is no illegality, my lord, in appointing me, my lord. That's all, my lord.
Arguments heard, judgment reserved.
Much obliged.
Deeply obliged, much obliged.
Item 34. Sorry, item 33 first.
Three.
Timing item 3 and 4.
Well, this is the. May I tell you one thing over here, because this stands of the department that they have accepted the fresh appointment. I have not brought in record in the contempt proceeding. So if the contempt proceeding,
How can we? It is up to them.
no, my lord, because I have not
is-
filed any affidavit in the contempt proceeding. So may I pray that
File an affidavit in contempt proceedings that they have accepted it, that is for the
that
contempt
is
court
why,
to decide.
yes, my lord. In fact, contempt is also listed today, my lord. So my lord may give me some time so that I can bring it on record by way of an affidavit.
What record?
They have accepted the fresh appointments.
That is for that contempt court, that is not for us.
Item 4 is the contempt matter, my lord.
Contempt matter, you file your response in this contempt petition, will consider that, but so far as regarding this item number 3 is concerned, review petition, either we pass an order that you have not explained the delay or you withdraw it, that's all.
Withdrawal will be difficult for me, my lord, without the instruction of department since I'm.
Okay. This interlocutory application
Instruction check today.
listed today for consideration. The matter comes upon for consideration of the interlocutory IA number 819/2020 with a prayer to condone the delay of 557 days in filing the present, filing the connected appeal. Filing the review, connecting review petition. Full stop. In the application under section, in the IA, it is submitted that, it is contended that the respondents after receiving of the certified copy of the impugned judgment has considered the matter at various levels and has finally decided to file an SLP before the Honorable Supreme Court against the impugned judgment on 10/7/2000, which date?
Well, page 52 was the last communication over it.
Page 52 was the last communication.
Of the additional affidavit filed in the IA.
They've taken a decision to file the, this SLP.
Yes, my
This
lord.
decision they has taken on which date?
My lord, just a moment, my lord. Page 39.
Page 39.
Page number 13.
On 18/7/2, in view of judgment dated 10/7/2018. Various level and ultimately on 18/7/2018, the decision was taken that a SLP be preferred before the Honorable Supreme Court. Full stop. Is further contended that during the time of filing of during the consultation with the advocate on record in the Supreme Court, it was transpired that some facts have not been brought into the notice of the High Court at the time of passing of the impugned judgment, and therefore a decision was taken to file a review petition. Full stop. From the contentions of the appellants, it appears that in the year 2018 itself, particularly in December 2018, the state was advised to to prefer a review petition against the impugned judgment. Full stop. However, despite a decision being taken in the year 2018, in December 2018, this review petition is preferred before this court
On 18/2/2020.
on 18/2/2020. Full stop. No explanation is offered on behalf of the state regarding the delay running from 2000, regarding the period of delay from December 2018 to February 2020. Full stop. In such circumstances, we are of the view that the delay in filing the connected review petition has not been explained satisfactorily by the state. Hence, we don't find any case for condemnation of the delay of 557 days in filing the present review petition. Consequently, the IA number so and so. Dismissed. Yes, Ismail, you want to file response in item number 4?
Yes, my lord.
Learned counsel for the respondent raised for and granted time to file response to the contempt petition. List after 4 weeks.
Obliged, Lordship. We are deep. Yes.
Other order thing, we dictate with the respondents will, applicants.
Applicants, जहाँ पे respondent है, applicants.
Only second line to the sub.
Item 33.
May I please, Lordship? In this case, my lord, the petitioners are initially appointed in the upper primary school, my lord, as assistant teacher. And during their service, my lord, they have acquired the eligibility as trained teacher and obtain the training, my lord. And as per the provisions of the ROP 2017, my lord, those who acquire the eligibility criteria for the trained graduate teachers, they are entitled to the grade pay of rupees 8,700. And accordingly, my lord, that all the teachers in the state of Assam serving in the upper primary schools, they are given the benefit of 8,700. And these teachers, they have been denied, my lord. And hence this writ appeal, my lord. In the writ petition, my lord, while deciding the issue, my lord, the Honorable Single Judge has accepted the contention of the respondent authorities, and those contentions, whatever Learned Single Judge accepted, my lord, those are not actually depending upon the records of the departmental records of the respondent, my lord. As a result, I have filed the additional affidavit, my lord, in these proceedings in order to bring on record, my lord, the proceedings and decisions with regard to the grant of 8,700 grade pay to the teachers who are initially appointed in the upper primary schools and got their training and eligibility as a trained graduate teachers, and thereafter amalgamated with the high schools and the higher secondary schools, my lord. Their government has decided in those cases, my lord, to grant them the benefit of 8,700 grade pay, my lord. This is the sum and substance of the, my lord.
The Learned Single Judge has non-suited you on 2 grounds.
Yes.
First, that you are not possessing, you are not having the degree of graduation. And second, that you have also not produced any evidence to the effect that you were drawing grade pay of 8770 at the time of amalgamation.
Yes, Lordship. These are two things. But the actual my position in the field, my lord, on the after completion of the graduation and training, required qualification to become the trained graduate teachers, the authority gives the benefit of 8,700. And in this regard, my lord, I have annexed the orders of the authority, my lord, in the writ appeal memo, my lord. Annexure 3A, page 75, my lord.
Yes.
On the annexure 3A, page 75, your lordship will find as an to produce the example, my lord, I have given the order in respect of 3 persons the authority has given.
For
Though,
that, the learned single judge has observed that even though if those persons were granted illegally, you can't claim that illegal.
No.
You are also required to get those.
This is not illegal, my lord. This is as per the policy of the government, my lord. May I place from my additional affidavit, my lord, additional affidavit page that I have given in the writ appeal, my lord. Additional affidavit, my lord.
Writ appeal.
Yes, lordship.
Why you are not furnished those documents before the single judge?
My lord, before the single judge, on single judge, my lord, it was not at that time available with me, my lord.
With me, that this
And
then how this judgment of the learned single judge is bad? You have not produced any documents. Then how can you say until and unless those documents were there, the learned single judge should must have expressed his opinion, might have expressed his opinion. If those documents are not there, how can we consider those documents here while considering the validity of the judgment passed by the learned single judge?
My lord, in the writ appeal, my lord, when I filed this writ appeal, my lord, the respondents have been allowed to file the affidavit, my lord. In order to that, my lord, to counter that, my lord, I have filed the reply, my lord. They have been allowed by this honorable court to adduce the further documents, my lord.
Yes, what do you want to show?
Page number 195 of the, my lord,
What?
195 of the additional affidavit.
Yes.
This is the minutes of the, my lord, department, where department has decided to grant the, my lord, the benefit of 8,700 along with rupees 300 as special allowance, my lord.
For those persons who are not having the qualification of graduation.
Yeah, not having the graduation, who have acquired the graduation, my lord, and acquired the eligibility criteria, my lord. So we have acquired the eligibility criteria in the meantime, my lord. Those have been granted.
When?
In the we have acquired the eligibility criteria in the year 2018, my lord.
2018,
my lord. We have given the certificate of the elect. Page 51, 52, and 53. These are 3 certificates of training per certificate. In the
read this second para of page 95, minutes. The members were informed that the several proposals allowing graduate scale of pay to the graduate teachers working in the upper postgraduate, under
graduate post in amalgamate
higher secondary and high school are pending for a long time. Hence, a conclusive decision should be taken on the matter and entitlement and review of the recommendation of the anomaly committee. Government approval to the recommendation. Also, as a matter of fact, that the teachers of different districts are already drawing pay in graduate scale since the date of amalgamation of their school.
Yes,
Here in your case, this was not the case. You were not getting that pay.
but my lord, those teachers who are serving in the upper primary schools but not amalgamated, they have been granted the benefits of 8,700 that I have annexed with the page number 75. That I have given the page number 75. Yeah, just because we have been amalgamated,
That benefit was granted to those persons who were already getting.
we are in the
this.
same footing. We are in the same footing, my lord. We are having the graduation qualification. We are having the training, my lord. And we are serving in the high schools, my lord. And we are teaching in the same class. We are doing the same service. We are rendering the same service. And even the teachers like us throughout the state of Assam, they are getting. Teachers like us throughout the Assam, this honorable court once asked for the data, my lord. They have not submitted the data, my lord, though it was initiated to ask from the block level.
This meeting.
And thereafter,
not
speaking
only
order is
your
there,
case.
followed by that, my speaking order is there, page number 200.
Show us any order in the intermediate period, intervening period, the persons who have acquired the graduation qualification are also entitled for this benefit. You show us any document.
Page 75 of the appeal memo, my lord,
75.
of the appeal memo.
Yes. The following teachers showing there against the name hereby allowed to enhance the grade pay, considering he is known as a trained graduate teacher for his. Where is that they acquired this qualification later on?
Yes, my lord, because they were
They
given.
were not having this qualification at the time of amalgamation, but they have acquired this qualification later on the government, and the government has allowed them this grade pay of 8700.
Yes,
Yes, what yes?
my lord, those teachers who are serving in the upper primary schools, my lord, they are even today, even they complete the, my lord, the degree and training, my lord, they are given. This is. And this is the result of the order, my lord. This is the order given on 2019, 7/3/2019.
You are paying those persons who have acquired this graduation qualification later on.
Education department, my lord. What has happened is this. They are teachers in lower primary schools where the entry level qualification is intermediate, and at the time of the appointment, my lord, DLED was not even a required qualification to come into service. During their service period, DLED was made mandatory by the NCT.
During that period?
Of service, my lord, the NCT made the requirement of DLED mandatory to be a teacher in the lower primary schools. Pursuant to that, they underwent the DLED course and they got the DLED certificate under the NIS, which is an 18-month scheme. In their own service, while they were serving, my lord, they also acquired their graduation degree. Now, what they seek to say is, since we have acquired the graduation degree and since we have the training DLED with us, we are entitled to the pay of a trained graduate teacher. Department wants to bring about the difference, saying when they came into service, they were untrained and they did not have the graduate degree, and therefore they were inducted into service on the basis of their intermediate qualification, and therefore they are entitled to the pay scale of an intermediate teacher. Now that they are trained, they would be termed as trained intermediate teachers at best. They are acquiring the graduation while in service, which did not help them to get the appointment in the first group. Cannot be taken into account to nomenclature them as a graduate teacher. And therefore, they are entitled to the pay of a trained intermediate.
Saying that similarly situated persons were.
Page 75, Lordship will find, is an order passed by the Deputy Inspector of Schools, not by the government, and this was pursuant to the ROP 17, which there was a confusion in the nomenclature made. And this matter, what is a trained graduate teacher and what is a graduate who is a teacher with graduation? This nomenclature being confused, people were given, I have got the data, people were given the scale for certain period of time. ROP was thereafter amended to bring in to make the distinction clear.
Having heard the concept of the parties at length, we are of the view that matter requires consideration and admit parties are already represented. No need to issue notice. Office to proceed.
Item 24.
Hello, in this case, my lord, they accept response number one. Other has responded. My lord, the last order that was on 1/6/111, my lord. 6/11, there was a my lord direction to file the affidavit by respondent number one. My lord.
6/11. Solicitor General, respondent pharmacy plays a further opportunity each time to do the needful.
My lord, his time may be granted to file our response, my lord.
To whom?
My lord, I'm
The
waiting for
pharmacy-
respondent number one, my lord.
Pharmacy Council of India.
Pharmacy Council of India.
Then this. Earlier, this Deputy Solicitor General was granted time to file
Yes,
reply
sir.
on behalf of whom?
Or respondent number one, my lord. Pharmacy Council of India.
The earlier time was granted.
My lord, last chance may be given, my lord. Within 3 weeks, we'll file our
Now
response.
Mr. Chaudhary is not appearing.
My lord, he is appearing, he's in another court. That's why I'm appearing today, my lord. That's why, my lord.
A request is made on behalf of respondent number one to grant further time to file reply to the petition. Time for is granted in this chapter 4 weeks.
Mass complaint.
No, sir.
Supplementary list, item 44 for admission.
May I lordship, my lord. My lord, I am, my lord, just now I have received a Okalot number on behalf of my lord SBI. My lord, at least 1 week time I begin, my lord, take instruction, my lord.
Last occasion.
That's what he is appearing, my friend is appearing, my lord, but
I was there here only last.
the case was not allotted to him, my lord, that's it.
The bank have appointed him as the company.
Bank has
Appointed him as the.
appointed.
Just now when I have received a Okalot number.
This client is ready to pay all of the
No,
amount.
my lord, today, my lord, I am on a handicap, my lord. But at least 1 week time, my lord.
Password for the day,
Next week, my lord, Monday,
Tuesday,
Tuesday.
Deeply.
while showing name of Mr. So and so as counsel for the respondent. क्या फर्क पड़ रहा है आ रहा है बिल रेज कर देना ना Send for bail to the SBI.
Deeply.
Daily list for hearing, item 35 to 37.
These appeals are against order dated 28/2/2018.
Yes, lordship.
But these are interim orders.
Interim order.
What has happened to the writ petition?
It is pending. Finally, it was stayed here. And the person against whom the grievance was raised, because it was a challenge of the recommendation of the selection committee on 18/9/2017 for selection of non-state civil services for IAS nomination. Those two persons were nominated and the main selection order till now has remained unchallenged. Both of them have superannuated also.
What is regarding, I think so, what we have, now, on the last occasion, we have heard this matter for quite long time.
No, this was not heard.
This was the matter.
In fact, I sought
Where
adjournment.
your main objection is regarding the maintainability of the.
Lord.
Yes, they wanted to say.
And so far as regarding this inclusion of the non-respondents, the respondent petitioners, that the court has specifically given a direction, can explain under what condition you have nominated their name or sent their names. But since they have already retired.
Yes.
Now the matter whether the state, whatever the grievance you have raised.
Yes.
Is to be decided by the learned single judge.
Yes.
My humble submission is, Lordship, if Lordship is pleased to come to page 42, their prayers in the writ petition.
Yes.
Their first prayer is that they want setting aside and quashing of the impugned selection process. That impugned selection process was not the selection process, number one. But whatever, the selection process which took place in the month of December, what they are challenging is the sorting up of the names who were sent for the selection committee's decision. That is considered as a selection. That is not selection. That is shortlisting, number one. That has no meaning now. Prior to is 18/9/2000. That is the so-called selection. In fact, it was not a selection in terms of the IAS rules and regulations. They have challenged another notification that is of 27/10/2017, where the equivalency was granted. That issue may have some importance till date for the subsequent, but that can be always considered in an appropriate case because that has no meaning now.
That writ petition also that can be considered.
Because
after
the
recommending
main
their,
player,
after recommending their name, you have passed an order regarding equivalence. That was after that.
the learned single just held that after the selection, the equivalency was issued. In fact, the selection took place in the month of December. This was issued in the month of October, and the sorting out had taken place in the month of September. September's sorting out is considered to be the selection. From the record, I'll place the minutes. If Lordship is pleased for a moment. That first selection, then the minutes of the sorting out. Yes. Page 104, Lordship will sorry. No, selection. Committee, yes. Lordship will kindly come to. Minus state government. Yes, page 74. Or second petition. No? This is the. Yes. Lordship will kindly come to page 106. Yes. Minutes of the meeting of the selection committee. This wording selection committee was loosely used.
Date of selection is.
Date of selection is, Lordship will find that at 21/12/2017, page 115.
18/9/2017.
18-9, that is not the selection, that is the sorting. For prepare, that is why I'm coming.
Sorted out two names,
No, we have not sorted, we have sorted out 10 names.
and out of these two persons were
These two persons were selected by the UPSC.
selected by the UPSC. That annexure 6, where is the annexure 6?
Next, Lordship will kindly come for a moment, just one for a moment, 106. Lordship will kindly see the minutes of the meeting of the selection committee for preparation of the list of non-SCS candidates to be recommended for notification to IS for the select list so-and-so held at so-and-so.
But 10, this annexure 6 page
74.
74.
There are two actually, that is why we are getting a little bit confused. Lordship may kindly take the state's appeal 167.
Page 74 is also there.
Same thing is in different pages, Lordship. That is the,
Page 74, this you have sorted out 10 names.
yes, 10 names.
Consolidated
This is not selection.
consolidated statement of non-state civil service officer eligible for consideration of the appointment to the IAS as on 1st January of the select list of year 2016.
Now,
So you have already, the statement you have included their name without there being any order of equivalence of their post.
the thing is like this, Lordship. In the month of February, a notification was issued by the state of Assam to all respective departments, whoever is willing to be a part of this selection, send us the names. 10 names came. Sorry, 15 names came, and from that 10 names were recommended. Now, the actual selection in terms of regulation 3 of the IS regulation, Lordship, that Lordship will find at 113. Before that, Lordship will see who are the persons here in the first sorting out. VK person as Chief Secretary Assam, Alok Kumar, Home and Political Secretary, Additional Chief Secretary, Ravi Kota, Principal Secretary, Dibedi, Commissioner and Secretary. These are all state persons. They cannot be the selection committee. February order for a silver. I mean, if it is I agree. Lost February order.
Then, so far as regarding this selection and appointment of respondent number 8 and 9 or whatever the private respondents, that part is over.
That in fact, on 19th of December, they were appointed. That is not put to challenge also.
Yeah, that's another thing.
Lord.
But now the matter remains, and so far as regarding the finding of the learned single judge regarding the maintainability of the petition, we say it seems that that is quite reasonable.
Lordship, that is where we have to argue.
Oh, that's quite reasonable.
Lordship may be pleased to
quite
express
reasonable.
the opinion, but without hearing me, I'll have to place my case. Lordship will then decide the same thing.
This is also a tentative opinion, but quite reasonable it seems.
It seems, but it is directly in conflict with the one Supreme Court judgment and one High Court's order, High Court judgment. Directly. We are not shying away from, because there is absolutely no illegality in my humble submission. Because Lordship will kindly take one moment.
That we don't want to make any comments on.
Yes, Lordship may not be pleased, but only thing is that the learned single judge has made that manifest mistake by considering the 18th September's minutes as the selection. The minutes of the 21st December is the selection. That is what I would like to place. Page 30 for a moment, Lordship may kindly see.
That is for the learned single judge.
No, just for Lordship, for our satisfaction.
Maintainability question.
That is why maintainability. This committee has to be constituted in terms of Regulation 3. And who can be the part of the selection, this selection committee? Regulation 3 says there shall be constituted a state cadre or joint cadre specific in column 2 of the committee consisting of the chairman of the commission. That means UPSC's commission chairman, or where the chairman is unable to attend, any other member of the commission representing it and other members specified in the corresponding entry in column 3 of the said schedule, provided that no member of the committee other than the chairman or the member of the commission shall be a person who is not a member of the service. 2, nominee of the government of India shall not belong to the cadre of the state for which the meeting of the selection is to be held. The central government may, after consultation with the state government concerned, amend the schedule. In terms of that, the selection committee is schedule is also cleared in the rule. That meeting had taken place. Lordship will kindly come to page 100 and page 113. This is the selection where Sujata Mehta, the president of UPSC, was the chairman, V.K. Pipersin as chief secretary, T.Y. the chairman, Assam Administrative Tribunal, 4, Arun Bakoria, joint secretary, Ministry of Drinking Water and Sanitation from the central government, and Rajesh Kumar Singh, CBO, Food Corporation of India, page 113. And the selection had taken place on 21st December 2017 at page 115. This is the selection. Whereas the learned single judge in several occasions in that judgment, Lordship has held that the September selection is the selection. Therefore, that issuance of the notification of 27th October preceded this selection, not succeeded.
That is on merits.
That is on merit, Lordship.
It is on merit. They are simply concerned regarding the maintenance.
If Lordship is, because the maintainable part, Lordship, I have to place the law as well as the judgment. Maybe on some other day, if Lordship pleases, or today itself, I am ready because I spent the whole morning studying this case. So is my friend also. But he is from the private respond.
I am from the private respond. But our whole case also is that we pleaded before the learned single judge that 1, the writ petition is not maintainable. It is only the purview of the central administrative tribunal. Number two, I raise in my applicant vacating that whether it is an agreed person or not. Because it is a selection in respect of non-ACS and he is ACS. So that also, whether the percentage, 33, 1/3 or 15%.
Mr. Consul, so far as regarding the other arguments of yours are concerned, now we are simply considering regarding the maintainability of the petition because now
that
we
will
don't want to make any comment on the merits of the case since the matter is pending before the learned single judge.
Lordship, my humble submission is.
But if your Lordship hold that for a moment, that writ petition is not maintained. For a moment, then why not, if the writ petition, then it goes, then either
either my learned friend Stan has to take the help of the central administrative admin. If at all. And
Whatever
suppose-
advice
No.
be given, that is not our concern.
Even if your lordship holds that is maintainable, then of course it will go for learned single as the merit of the case. Yes. That's what, but what we are on the point of maintenance.
Yes, that's all.
Our affidavit, there was one vacating petition, and my submission also before the learned single judge, as well as the other senior counsel, only limited to the maintainability point. And on identical case in Arunachal bench,
Whatever the law you want to.
I'd like to
supply
place
us the
lordship,
copy.
I'd like to argue on that.
You supply us the copy, we'll
Yes.
go through that and then.
Lordship, two
argue.
judgments,
Yes.
only two judgments, one
We are fixing in the next week. You just supply the law.
lordship,
Yes. Whatever the,
1997.
you give us the copy.
Yes, I have already given the book list.
The photocopies of the judgment.
Yes, I'll give it, lordship.
Two copies, photocopies, we'll.
Yes,
consider
lordship.
it.
Three
And then
judgments we will
In the
place.
next week, we'll
Lordship.
consider this point. Mr. Chaudhary, if you.
Well, I'll rely on the same very judgment which my learned friend will rely. Para 99
Then
will
you
rely.
decide by yourself what to do.
No, my lord.
Both of them.
No, my
You have
learned
the
friend
same
is,
judgment.
no, my learned friend is
Deciding
relying upon.
yourself.
Whether there is any
Kumar.
ambiguity in the judgment or not, that lordship will have to look into.
No, L. Chandra Kumar, my learned friend is relying, my lord.
You are
Para
also-
99, I'm also relying.
I'm relying on 93 also.
Any.
You supply.
Well,
us the
just
copy
now,
of the
lordship.
judgments and,
Just law.
Mr. Chaudhary, if you are also supplying some copies, supply us, we'll
Yes,
go
yes.
through it. And then, in the next week,
Tuesday could it be lordship or maybe Thursday also.
Thursday की 29 हो रही है 29 ना लगे 29 में लिख दें मतलब not on 29th and first any other date my lord
27th,
27th.
Lordship.
27th. List on 27th.
Highly obliged, lordship.
Whatever the law you want to.
Lordship,
Same judgment.
It's
One
very
judgment-
strange.
Judgment is-
All of you are relying on the same judgments, then what remains? Get yourself, decide your controversy yourself.
highly obliged, lord.
Item 38,
We'll hand over the copy of the judgment. I have got two copies of.
Right, on behalf of whom, you please, make a note of them.
so take it Allah, will it suffice if we give it tomorrow at 10:30 my lord we'll give the printouts if
Commissioner heard that there were many irregularities.
Yes.
So hearsay petition,
Lordship,
hearsay petition based on hearsay.
we have there's substantial document in this PI to show that there are glaring irregularities in the minor irrigation schemes.
Please, Lordship. Lordship, we have filed additional affidavit yesterday, Lordship, bringing it on record the subsequent public litigation petition filed by Shri Longkumar Bay in the year of the 2019, Lordship, where the same kind of petition, Lordship. And there is another petition, two other petitions, 37 to 2019 and 55 of 2019 PIL, Lordship.
What happened in those petitions?
Lordship, the cause of action, issue raised and relief sought are all similar, Lordship. There also the non-completion of irrigation schemes. Non-completion of minor irrigation scheme.
What happened in those petitions? Those petitions?
It has been disposed of, Lordship.
Disposed of?
Yes, Lordship, that's
What
why.
orders they have passed? What are the orders?
It's in our additional affidavit, Lordship, which is not in the record right now.
Lordship, yesterday we served with the additional affidavit. We have gone through the orders in that the petitioners were directed to approach the principal secretary for to see.
You also approach the principal secretary.
Yes, Lordship, I may be given a day or two. I'll seek instruction from my the petitioner and I will get back.
Okay. This public interest, this petition is filed by the petitioner in the design of public interest litigation, raising a concern about the various irregularities conducted by the officials of the state of Assam in completion of the minor in implementing the minor irrigation schemes and flow irrigation schemes. Full stop. Learned concept of the respondent has submitted that similar type of writ petitions in public interest has already been disposed of by this court, and details of the same are provided in the additional affidavit filed on behalf of the state. Full stop.
Lordship, Karbi Anglong Autonomous Council, Lordship. We are for respondent number 9, Lordship.
On behalf of the Carbiana Autonomous Council. Full stop. The additional affidavit filed on behalf of the Carbiana.
Additional
Autonomous
chief
Council.
engineer, additional chief engineer.
Stop.
Irrigation.
The affidavit, it is on record or no?
No, Lordship.
The affidavit is on not record. Office to take the same. Unless this matter
Lordship, may it be on Tuesday, Lordship.
Tuesday.
Lordship, I'm sorry to mention at this hour, my lord. Item number 40 and 41 was adjourned without taking permission. I was waiting whole day, my lord. And my lord, I don't know, nobody has informed. Just now, my lord, just my junior secretary, it was informed it was adjourned. Without
adjourned
giving
in the
any
morning
concern,
itself.
without giving any information, my lord.
In fact,
Somebody, my
they
lord,
made a mention that some wrong matter was listed along with
yes, somebody, I don't know, my lord.
40 and
One
41.
lady, some lady has mentioned, my lord, from the other mention. I don't know who has mentioned it, but I'm waiting. Can it be, my lord, little bit earlier, my lord? Because of that case, my earlier also they have, without information, they have taken time. Next Thursday or next Tuesday, my lord. It is utmost
In fact,
urgent,
what
my lord.
happened, we have already signed the order sheets.
Tomorrow
Otherwise,
again,
it's
date is
very
also
difficult
not
now to
fixed.
change the order sheet.
Date also not fixed, my lord. So, again, I have to mention, then I will mention it tomorrow or next week.
Yeah, after 2 weeks, ensure that date will be fixed. We'll
Because
ensure
without
that
information,
it will be
earlier
listed
also, my
after
lord,
2 weeks.
it was listed before court number 2, everybody was waiting. Then, my lord, somebody mentioned in the morning without information.
Morning.
This time again happened, my lord. Yes.
We'll ask them next time that they'll.
I don't
inform
know,
you in
that's why, my
advance.
lord, I don't know who is it. That's why the difficulty is there.
We'll make sure on the next day that
Or can it be fixed on next, my lord, next week, my lord, Tuesday or Thursday?
in fact, we have
5,
already
6 years has,
we have already signed the order
7
sheets.
years has gone, my lord. The case is.
We have
about
already
around-
signed the order sheets. That's why it's difficult to
Okay.
change that.